Good morning, everybody. My name is Judge Kim Teresa Malika. You're in first appearance magistrate court. We're going to review the probable cause review the police reports and see if there's probable cause and determine a bond. Today is not your trial day. Please do not talk about the facts of your case. Everything's being recorded. You have a right to remain silent. We have Mr. Romero at the main jail, and we have Mr. Reedy from the public defender's office to my right. In the main courtroom, if you have a private attorney, please let me know. Mr. Romero, we have to take the MO cases from Mr. McLaurin because he has a trial today in front of Judge Pohl.
Oh, no problem, Judge.
That's
No
why I
problem.
started a little early. He's got to get up there,
problem.
okay? All right,
No problem.
so first person's going to be Kelly Scott. Are they at North Broward or main jail?
Yes, Judge, North Broward. She's on
Okay.
page 2 of the docket.
Okay, thank you.
And Judge, just so the court is aware, she declined my services,
Okay,
but I did want to let the court know that she says that she has a valid address. Well, she's not there, Judge.
okay. Kelly Scott, please, North Broward.
Good morning, y'all.
Hi.
Good morning, Ms.
Kelly
McLaurin.
Scott, page 2. Good morning. How are you?
Good morning.
Hi, Ms. Scott. How are you?
I'm okay. How are you?
Good. All right, Mr. McLaurin, you have a right to have an attorney appointed if you can't afford one or for magistrate purposes. Do you see Mr. McLaurin? You want to decline his services and represent yourself? What would you like to do?
I will represent myself, ma'am.
Okay.
Good morning.
All right, so you have 3 charges. You have trespass after warning, obstruction of justice, and resisting without violence. Bond set at $100. Can you make the $100 bond?
Will you please release me on a personal recognizance because I never received a no trespassing and I'm going through a lot right now. So I would appreciate that. I need to I've already started working. I own my own company in Ocala, Florida, and I already started working on this through the court up there to hold people accountable for certain inappropriate things that put me in certain situations that are inappropriate, but
Okay, here's the situation. You got to come back to court, otherwise you're going to have a warrant for your arrest.
I will. Yes,
Okay?
ma'am.
All right, so actually, on count 1 for the trespass, I'm not going to find probable cause. The court does find probable cause on counts 2 and 3. And is your mailing address, let me just check that, 620 Southeast Sanchez Avenue, B. Ocala.
That's correct.
All right, ROR, good luck to you, ma'am.
Thank you.
All right, next one is Nancy Dawn Klein.
And she's on page 1 of the docket. She's also in North Broward.
Oh, okay. The other one was at the main jail?
Yes, Judge.
Okay. All right, good morning, Miss Klein. You have,
Good
do you
morning.
see Mr. McLaurin, your attorney here?
Yes, I do.
She has 2 attorneys, Judge. She also spoke to Mr. Reedy.
That is
Oh,
correct, Your
okay.
Honor. Ms. Klein indicated to me that she would like to resolve the case today. I did advise her that a 3rd conviction for petty theft could result in a felony. I also advised her that court costs would be involved and that if she did not pay those court costs, it could have an adverse effect on her driver's license and her credit rating.
Good. All right, so what say you state on count 1?
I'm gonna need a minute, Judge.
Okay, the court does find you charged with petty theft, 2nd degree, 2nd offense, $100 bond, and then count 2 is an MO for petty theft as well. Court does find probable cause. Court's going to order no return to the Publix located at 1940 Cordova Road, Fort Lauderdale, Florida. If you go back there, ma'am, you'll be arrested. Do you understand?
Yes, ma'am.
All right, thank you.
Thank you.
Let's, hold on, we're gonna, ma'am?
Oh, I
We're gonna,
apologize.
that's okay. We're gonna see if, do you want to try to resolve your cases today?
Yes, ma'am.
All right, let's see what the offer is from the state on the petty theft 2nd degree from Publix. And then we'll, see if you want to take that plea offer, okay?
Yes, ma'am.
All right.
The offer would be a time served.
Judge, in the MO case, Your Honor, I looked on her the clerk's website. I didn't see anything in the last 2 years. I don't know if she has anything in the last 2 years, but I was going to ask you if you would withhold on the MO matter.
No, because she has 2 of the same, adjudication time served,
Okay.
$78 in court costs on the MO and $293 on the MM case.
Okay.
Okay. Is that what you'd like to, is that what your client would like to do, Mr. Reedy, or?
Yes, Your Honor, that's what
Okay,
Ms., that's what
raise
she
your right
indicated
hand.
to
Do you
me.
swear and/or affirm to tell the truth?
Yes, ma'am.
All right, it's my understanding you want to resolve both your cases today, ma'am. The petty theft, second degree, second offense, and then the petty theft. Is that correct?
Yes, ma'am.
All right, put your hand down. Is your name Nancy Dawn Klein, Kline?
Yes, it is.
All right, your attorneys have told me you want to give up your right to a trial.
Yes.
Anybody forcing you to do this?
No.
Are you under the influence of any alcohol, drugs, or medication?
No, ma'am.
Okay, I just have to ask a bunch of questions to make sure you're doing this freely and voluntarily. You understand
understand.
also, ma'am, that if you get a second arrest, and you have 2 prior convictions for theft, the third one could be a felony, even though it might be a misdemeanor regularly. Do you understand?
Yes, I do.
All right, and understanding everything that I explained to you, do you want to plead guilty, not guilty, or no contest to petty theft, second degree, second offense, and then another charge of petty theft?
Guilty.
Okay, the court's gonna accept your plea, find that's freely and voluntarily entered. Court has reviewed the court file and finds probable cause for the plea. Adjudication and time served on each count. On the petty theft on the, state case, it's $293. On the MO case, the court costs are, $278. Court will give 6 months to pay on each one, no return to the public, ma'am. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. Thank you, ma'am. Good luck to you.
Thank you very much.
All right, we're gonna take,
Judge, lastly, on page 11, Giovanni Chisholm, I was told that he bonded.
okay, so let me do a bonded. All right, thank you. Good luck in your trial. All right, so we'll take a break for about 5 minutes. I just have to finish reading something. Thank you. Maxine Scarlett, please.
No problem, Judge.
Okay, good morning, Miss Scarlett. You have 2 capious misdemeanors. Oh, wait, I'm sorry, this is an MO case. Ma'am, we're gonna have to recall your case at 10 o'clock, okay?
Yes, ma'am.
Yes. Yes. I got them. Stephanie Mawa.
No problem.
And Deputy at North Broward, we're gonna continue, we did Mr. McLaurince's cases, obviously, this morning earlier. We're gonna do Mr. Shates around 10:30 when he gets here, okay? So if I call them, I did it by mistake.
Okay.
Okay, excuse me, hold on. Okay, Ms. Mawak, good afternoon, ma'am. You have obstruction by disguised person, $100 bond. Count 2 is resisting an officer or obstructing without violence, and loitering or prowling, bond set at $100 only on count 1. The other 2, bond is not required. The court does find probable cause. What say you, Mr. Reedy?
Your Honor, in speaking with Miss Maya, she indicated to me that she would like to resolve these charges this morning.
I can't hear him, I'm sorry.
Oh, sorry, I didn't have my mic on, I'm sorry. Miss Maya indicated to me, Your Honor, she'd like to resolve these charges today if possible.
Okay, state.
One moment. Offered be a withhold court costs, all counts.
Is that what you'd like to do, Miss Maya? Accept the plea in exchange for a withheld adjudication, which would be no conviction on your record, and court costs?
Yes.
Okay.
If you want to be released on your own recognizance and come back, you can fight these charges as well. I'll ROR you. However, if you don't come back, you're going to have 3 warrants out for your arrest because there's 3 charges. So do you want to
What does,
resolve?
I would-
ROR means I'll release you on your own recognizance, but it means you get out of jail for free. You don't have to post a bond. But if you don't come back to court when you're supposed to, then you'll have a warrant out for your arrest, and you'll have 3 of them because you have 3 charges.
you can go ahead and let me go, and then I will definitely come back for that court date.
Okay, what's your mailing address?
2910 Northwest 56th Avenue, apartment C413, Lauderhill. Of course, Florida 33313.
2910 Northwest 56th Ave, apartment C14.
No, C413.
C413.
413. Yeah.
Correct. Okay. All right, ma'am, good luck to you. Look for your court date.
Thank you.
Thank you.
Good luck.
Mildred Pearson.
Judge, Ms. Pearson is here at me.
Okay, Miss Pearson, you have driving with the suspended license, $500 bond, you no-showed at arraignment. Court does find probable cause for your arrest. What say you, defense?
Judge, in speaking with Ms. Pearson, I had a long conversation with her. I was going back and forth, but at the end of the day, she wants me to ask the court if you would consider resolving her case today.
Okay, she has. State, what's the offer?
Offers withhold court costs.
Withholding court costs.
Let me explain one additional thing to her, Judge.
Okay, ma'am.
I explained to, Ms. Pearson as far as the court costs, that the court would give her 6 months. What happened was, unfortunately, if she didn't pay it, that her driver's license would be suspended, and there would be an additional late fee as far as $25. Besides that, one of the side effects of resolving this type of cases, I did explain to her, is in a 5-year time span, Department of Motor Vehicles could suspend her license and declare her a habitual traffic offender, and if she's caught driving during that time span, it would be a felony. Having explained all that to her, she still wants me to go ahead and ask the court to resolve it, and she is accepting the state's offer, Judge.
Okay. All right, ma'am, raise your right hand. Do you swear and/or affirm to tell the truth?
Yes.
All right, can you have him hold it down a little bit at the main jail?
Hold it down.
All right, is your name Mildred Pearson, Pearson?
Yes, it is.
It's my understanding through your attorney, Mr. Romero, you want to give up your right to a trial and admit to your driving while license is suspended charge today?
Yes, sir.
Is
Yes, ma'am.
anybody forcing you to do this?
No, ma'am.
Are you under the influence of any alcohol, drugs, or medication?
Medication.
Does your medication, don't tell me what it is, affect your ability to understand what's going on here today?
No.
Have you ever been treated for a mental illness?
20 years ago.
Okay, does your mental illness affect your ability to understand what's going on here today?
No.
I just want to make sure you're doing this knowingly, okay? That's the reason for my questions. All right, you understand also that if you get 3 convictions within 5 years, or you get 3 driving while licenses suspended within 5 years, the Driver's License Bureau is going to revoke your license as a habitual traffic offender. Do you understand that?
Yes, ma'am.
Understanding everything that I explained to you, do you want to plead guilty, not guilty, or no contest to driving while license is suspended?
What is your plea?
No contest.
Okay, and you're satisfied with the advice of Mr. Romero, the attorney standing next to you?
Yes, I am.
You feel that pleading no contest is in your best interest?
Yes.
All right, court's going to accept your plea, find that it's freely and voluntarily entered. Court has reviewed the court file and finds probable cause for the plea. Withhold of adjudication, court costs $293, 6 months to pay, partial payments accepted. The court takes judicial notice of the time that you served in the Broward County Jail. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. Thank you. You're done with this case, ma'am, except for paying your $293. Madam Clerk, if you could make sure that you just write judicial notice of, you can put TS and BCJ, time served in the Broward County Jail. Thank you. Felicia Fisher.
North Broward, Your Honor, Ms. Fisher would like to resolve this matter this morning.
Okay, State, you have a plea offer?
One moment.
Hello, Ms. Fisher, how are you today?
Fine.
Ma'am, you have a procure for prostitution charge. You no-showed at arraignment August 13th. State, what's your offer?
Withhold court cost HIV test.
Ms. Fisher, is that what you would like to do? It's a withheld adjudication, which would be no conviction on your record, but you would have to pay court costs.
Yes.
All right, and I explained to you about the need that you're gonna have to go and get an HIV test within 30 days, turn in the receipt to the clerk's office within 45 days. You do not need to show them the results. Do you have any questions about that?
Yes.
What questions do you have?
I have no questions.
All right, and you understand there's gonna be court costs, and if you don't pay those, then that could affect your driver's license and your credit line. Do you understand that?
Yes.
Knowing all that, would you still like to go ahead, waive your right to a trial by jury, and enter a plea of no contest to this charge?
No, I just want to drop the charge.
I'm sorry?
Can I just drop it?
Do you want to plead no contest?
The charge isn't getting dropped today, ma'am. So you have 2 options. You can either go to court and fight your case and have a trial, or you can think about it for a while and go to court and maybe resolve it there. Or you can resolve it today.
I want to resolve it today.
Raise your right hand. Do you swear and/or affirm to tell the truth?
Yes.
All right, put your hand down. Is your name Felicia Fisher, Fisher?
Yes.
It's my understanding through your attorney, Mr. Reedy, that you wish to give up your right to a trial?
Yes.
Anybody forcing you to do this?
No.
Are you under the influence of any alcohol, drugs, or medication?
No.
Ever been treated for a mental illness?
No.
You understand that you have to take an HIV test in 30 days and provide the results, the receipt only, not the results, within 45 days to the clerk of the court?
Yes.
All right, how do you wish to plead to procure for prostitution? Guilty, not guilty, no contest?
Not guilty?
Well, not guilty means you want a trial. That's saying,
Okay, well, guilty.
okay.
I guess.
Well, you can't guess, ma'am. You have to be certain. You sound like you're unsure. So if you're
Yeah, I am
unsure,
unsure.
okay,
Okay, I guess guilty, so I can.
you want to plead guilty?
Yes.
You have to be sure.
No contents. I don't know. No contents.
Ms. Fisher, if you don't know, Ms. Fisher, you should not resolve your case. You have a
Okay, well,
$500 bond.
guilty.
Can you make that bond?
I can't make that bond.
Do you want to resolve your case this morning?
Yes.
Do you want to enter a plea of no contest?
Yes.
Do you want to give up your right to a trial?
Yes.
You have a right to have a trial, have 6 people from the community come in and listen to the facts of the case to determine whether the state has proven your guilt beyond a reasonable doubt. Do you want to do that?
No.
Okay.
All right, do you feel that your no contest plea is in your best interest?
Yes.
And you've had enough of time to speak to your attorney, Mr. Reedy?
Yes.
All right, court's going to accept your plea. Find that's freely and voluntarily entered. Court has reviewed the court file and finds probable cause for the plea, withhold of adjudication, which means no conviction, and court costs, $293 in court costs. I'll give you 6 months to pay that partial payment. Court takes judicial notice of the time served in the Broward County Jail. HIV test 30 days. Receipt only to the clerk of the court within 45. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. Thank you.
Oh, thank you.
Okay, Jasmine Alpizar. Bonded, okay, thank you. Jordan Croft, please.
Paul Ryan, Judge.
Sure. Okay, good morning. Are you Jordan Croft?
Yes, ma'am.
All right, you have an ad charge, grand theft between $300 and $5,000, $1,000 bond, and that's count 3, 4, and 5 are $1,000 bonds as well. Total of a $3,000 bond. Count 4 is illegal use of a credit card to obtain goods over 300, and 5 is fraud or attempt to use ID of another person without consent. $1,000 bond. Court does find probable cause. Court is going to order no victim contact, direct or indirect, with the alleged victim with the initials KK, which means no contact in person, calling, texting, writing, nothing on social media, and no contact through third parties, and that includes even if you're in jail. Do you understand?
Yes, ma'am.
All right, what say you, defense?
Your Honor, I spoke with Ms. Croft prior to court. She has on count 1 and 2 a court order to the Meridian program on Tradewinds Avenue in Lauderdale by the Sea.
Okay.
I would ask that the court order her into that program.
Is she on
counts-
pretrial or GPS?
It's,
Your Honor, Judge Porce entered a oral order on 1 and 2 pretrial GPS level 2 shall be picked up by Meridian Treatment Solutions.
So you want to do that?
I'd ask that it be the same conditions
Okay,
on all
GPS
counts.
level 2.
sure.
And
Go
then
ahead, I'm writing it down.
shall be picked up.
Custody to custody then?
I'm reading to you what Judge Porth wrote on the order.
Okay.
Shall be picked up by program Meridian Treatment Solution. And he already has their number and address on that order.
Meridian,
Treatment Solution.
okay. Okay. That's it?
That's it.
All right, so no bond required per the state and the defense?
Excuse me, Judge.
Yes?
I see a note from pretrial Teresa, can you verify? Apparently, when she went out on that order for pretrial handling, they said Michelle Lundy and Lisa Chanel, defendant cannot go. She is
I can't hear.
trial equipment.
Okay, hold on. We gotta make sure that our mics are on over here so these defendants
hear
can
any of
hear
that.
you. Okay, I'm gonna have her
Hang on,
repeat
Ms.
the whole
Croft, hang
thing.
on.
Apparently, when she was being released out on pretrial originally with that same order for count 1 and 2, per pretrial, Michelle and Lisa,
Who's Michelle and Lisa?
I guess they work for pretrial.
Okay,
This is pretrial talking to confinement.
okay.
They're saying that the defendant cannot go, that she absconded with the pretrial equipment, and they have advised Judge Porth that she must go back to court. So no, she's not being released to that program.
All right, so let's do this. Go ahead.
I was told that as long as the ankle monitor was paid for, which my mother did overnight a check to pretrial Friday night, and it was received Saturday according to the tracking number, that I would be allowed to get another ankle monitor. Since the first one, I have had another one, which was cut off by the arresting officer in Palm Beach County, and that has been accounted for. So I was told that as long as there's been payment made, that I would be allowed to get another one.
Would pretrial like to add anything?
The only thing I see in the notes is that they made contact with her mother, who indicated she was going to overnight a check. I don't see anything being received. I heard her say something about Saturday per tracking. I don't have any update on that.
All right, let's reset this to 1 o'clock. Does your mother have a number?
Yes, and I have the tracking number, but it's in my cell. Not in my cell phone, in my cell here at Paul Ryan.
All right, deputy at North Broward. I'm sorry, at Paul Ryan.
Yes, ma'am.
We're gonna reset this at 1. Is she gonna be able to go back to her cell and get that paper, the tracking number for us?
Yes, ma'am. Absolutely, yes, ma'am.
All
I
right,
can give you my mother's number also.
all right, Mr. Reedy will take it. Go ahead.
301 332
Reset to 1.
8054.
All right, and that'll give,
What's your mom's name?
Carol, Carol.
All right, I'll give her a call. We'll
That'll
see her
give
this
the state
afternoon.
time to reach out to Judge Porf's,
Your Honor,
yes.
you're asking the state to,
I'm asking you to contact the ASA in there and see if this is the case. Just see if you can find out anything. If
well, I
you
don't know
can't,
if
then
they-
that's fine.
I'll find out, but I don't know if they're gonna know what's being provided by
That's
the
fine.
jail.
Just, everybody, just try to work on it. Okay, thank you, ma'am. We'll see you at 1. Lamia Marshall, please. That's reset to 1.
All right, Your Honor.
Hello, how are you?
I'm fine.
All right, you have an ad charge for count 9, unlawful possession, possess a personal ID of another, 5 or more. Bond is set at $1,000. The court does find probable cause. Court is gonna order no victim contact, direct or indirect, with the alleged victim with the initials XB and KS. That means no contact in person, calling, texting, writing, nothing on social media, no contact through third parties. That means
Yes.
even if you're in jail, okay?
Yes.
All right, what say you, defense?
Your Honor, I know Ms. Marshall was asking about the possibility of pretrial release. Unfortunately, counts 6 through 8 are no bond hold, so I would just ask the court to leave the $1,000 bond in place.
Okay, $9.99 then. Thank you, ma'am. Good luck to you. We'll do yours in 1 second. Who do we have left at Paul Ryan?
Mr. Sergeant, Your Honor. Page 22.
Sergeant?
Yes, ma'am, page 22.
Reset from yesterday.
Oh, he was in regular court, I think.
Yeah, I think so.
Yes. All right, Mr. Sergeant, good morning, sir.
Morning.
You have robbery, to change a charge to robbery, attempt no weapon. Attempted robbery, no weapon.
I believe that's what they did, yes.
All right, we have Mr. Reedy who's gonna represent you in the courtroom. Is this just a technical?
It is, Your Honor. You found PC for attempted strong arm robbery.
All right,
Robbery,
$1,000 bond?
And GPS, no contact, yes. I'm just requesting that the court place the same bonding conditions.
Okay, defense?
I don't have an objection to reinstating the $1,000 bond. Mr. Sergeant, can you make that bond?
No, unfortunately, I lost my job in the process of all of this, so no, I can't make
How
bonds for anything.
long have you been living where you live now?
I was staying at my uncle's house,
Can you stay there again?
possibly.
Do you know the address?
Yes, it's 4800 Southwest 48th Avenue, Davie.
Judge, depending on Mr. Sargent's prior record, I'd ask the court to consider pretrial release for him. If he has a valid address where he can stay with his uncle.
I'd really appreciate it.
State, what's his priors and the facts and circumstances? I'll look it
The
up.
facts
if you
and the
don't-
circumstances are that allegedly, Mr. Sargent and a co-defendant approached a man at a gas station and began punching him. He and his co-defendant were punching the victim in the face.
Okay, I'm gonna keep the bond, the original conditions. He's gonna have to pay $100 towards his bond.
All right, good luck, Mr. Sargent.
Thank you, sir. Good luck to you. Okay, who do you have, Mr. Shade?
That's a lie.
The individual I'd like to take care of right now is on page 17.
Who
His
was
name
that?
Page 17, Joe Da Silva.
Okay, hold on.
He's in Main Jail, Judge.
Yeah,
Here, he's
everything.
approaching. There's your private attorney, Mr. Shea.
Page 17.
All right, let me just, thanks, okay, you should just throw it.
Da Silva. It's the second one from the bottom.
Pardon?
It's the second one from the bottom, Judge. And Judge, I'd ask that we not have the charges read.
Okay, hold on, let me just see. It's not my second from the bottom, I can tell you that.
On page 17?
How many pages do we have today? Yeah. 22. Oh, page 17 here. I thought you meant at the bottom of my pile.
Oh, no.
JOA?
Correct.
Okay,
Yeah, see, that'd be perfect.
all right. Okay, are you Mr. JOA De Silva, sir?
Yes,
Can you see your attorney, Mr. Shate?
yes, again.
All right, counsel, you waive formal reading?
I do, Judge.
Okay. Sir, court does find probable cause unless I hear an objection. State, what say you?
Your Honor, on count one, I'm gonna be seeking no bond hold on the punishable by life offense. Upon a finding of proof evident or presumption great for first appearance purposes only based on the probable cause affidavit. If it please the court, I'll wait to make bond recommendations on 2, 3, and 4 until the court makes a determination on count one.
Judge, as for count one, we understand the nature of the charge and that it's punishable by life. We will be seeking to file a Nelson hearing in the division court.
Okay. All right, Mr. De Silva, I have reviewed the probable cause affidavit and other documents filed in your case, and I find probable cause on count one. I further find the proof of guilt to be evident or the presumption great. Therefore, on count one, you're going to be held without bond pending further order of the court. This order serves without prejudice for you to file a motion to set bond with the assigned division judge and request a hearing under State v. Arthur. State, let's go to counts 2, 3, and 4, please.
Yes, Your Honor. On 2, 3, and 4, first, based on the nature of the allegations and the totality of the circumstances, I'm going to be requesting a $75,000 bond on each count. I'm additionally going to be asking for an order of no victim contact with the alleged victims whose initials are.
Sir, can you do me a favor and hit the mic there?
The button in the middle.
Okay, thank you, sir.
Excuse,
Go
the
ahead.
initials are NG.
RNG.
No. They are NG.
NG,
Yes. IP
okay,
and DF.
and DF.
Yes. Your Honor, I'm also going to be asking, and this just applies to counts 2, 3, and 4. Should he be released on these charges or eligible for release on these charges at some point? I'm going to be requesting a pretrial release GPS monitor level 1.
Okay,
I'm also going to be requesting a passport surrender to the clerk of courts prior to his release, and an order of no contact with any minors. Your Honor, and the reason I'm asking for GPS level 1 and the passport surrender, it's not just a concern for safety of the community, but also I do have concerns. I see that he is originally from Brazil, and as the court is aware, there is, should he be released from custody and flee to Brazil, there's currently no extradition agreement between the United States and Brazil for individuals born in Brazil.
We understand, Judge, and I think I misspoke earlier on when I said Nelson here. I think I meant
Arthur.
here, yeah. We understand, so just like it be sent to the division.
Okay. All right, so this is what I'm gonna do. Court is gonna set no bond on count 1, 75,000 on count 2, 75,000 on count 3, 75,000 on count 4. Court's gonna order no victim contact, direct or indirect, with the alleged victims, which means no contact in person, calling, texting, writing, nothing on social media, and no contact through third parties. That includes whether you're in jail or not. The alleged victims have the initials NG, IP, and DF, and you are to maintain 1 mile from them. GPS level 1, and the pretrial services is on, obviously on counts 2, 3, and 4, since 1 is no bond. You are to maintain 1 mile from the alleged victims' home and school and work, if any. GPS level 1, defendants to surrender his passport to the clerk before being released, and no contact with any minors. Thank you, sir. Good luck to you. Thank you, Mr. Shade.
Thank you, Judge. Judge, I have several others. I'll come back when I'm done.
Okay, thank you.
Our Spanish interpreter is here.
Sure.
4 cases before the last case you just
Sure, I'll
called,
get 'em.
Mr. De Silva, is Osmel Galban Columbi.
Okay, I'm sorry. Say that again?
Osmel Galban Columbi,
What page?
15. He's like 4 before Mr. De Silva.
He's here at Main, Judge.
Okay, Madam Interpreter. COL?
Look under Galban, Judge. I think that might be the first.
Galban, Your Honor.
GAL.
Page 15.
Raise your right hand. Do you swear and/or affirm to translate from Spanish to English, English to Spanish, to the best of your ability?
I do. Good morning, Your Honor. Solange Sands, SAENC.
Is that the only one I have to pull?
At Main, nobody else told me that they require a Spanish interpreter, Judge.
Okay, so I'll check
I
with,
don't know if in the other different facilities.
all right, thank you, Mr. Romero. All right, are you Mr. Osmel Columbi?
¿Usted es el señor Osmel Colombi?
Sí.
Yes.
You have 1 count of possession of methamphetamine, $1,000 bond. Count 2, grand theft auto, $1,000 bond. Count 3 is possess and/or use drug paraphernalia, $100 bond. Total is $2,100.
Señor, usted tiene un cargo de posesión de metanfetamina, un cargo de robo de auto de grado mayor y también un cargo de posesión de parafernalia de drogas o de usar parafernalia de drogas. $1,000 para el primer cargo, $1,000 de fianza al segundo cargo y 100 al tercero, total 2,100.
Court does find probable cause. What say you, defense?
Vemos que hay motivo fundado de parte de la Corte, que dice la defensa.
Judge, in speaking, Mr. Galban, he advised me that his family will be posting his bond, so all I'm going to be asking the court to do is on count 3, ROR count 3, the $100 bond.
No problem. Count 3, the court will ROR, leave the bonds in place on 1 and 2. Is your address, go ahead, I'm sorry.
Thank you, Your Honor. De parte de la defensa, averiguamos que la familia, los parientes le van a pagar la fianza. Pedimos que por lo menos el tercer cargo quede en libertad bajo su propia palabra. La señoría de acuerdo, entonces libertad bajo propia palabra en el tercer cargo, y cargo 1 y 2 quedan igual. Y vamos a confirmar su dirección, señor.
I'd like to verify your mailing address, 8055.
Usted vive o llega al correo a 8055
Northwest 8th Street, Miami.
Northwest 8 Calle in Miami?
No.
No.
Judge.
No.
Please, do you know your mailing address, sir?
¿Cuál sería la dirección para que le llegue el correo, señor?
P.O. Box? Okay.
That's fine.
misma que tengo en la licencia.
He says it's the same address he has in his license, Judge? I'm sorry.
I don't have a problem with the P.O. Box, that's fine.
Está bien, nos puede decir la dirección del P.O. Box.
606-101 Northwest, Miami, Florida 33126.
Disculpe, de nuevo, por favor, 606-101, ¿qué?
¿Puedo
Northwest.
decir la de mi licencia? Que ahí me llega ahí también.
Claro, la dirección donde quieres.
9321 Southwest 8 Terra, Miami, Florida
Okay, disculpe,
33174.
the interpreter is going to ask him to go a little slower. Por favor, un poquito más lento, señor.
9321 Southwest 8 Terra, Miami, Florida 33174.
Gracias. 9321 Southwest 8th Terrace, Miami, Florida.
Southwest 8th Terrace.
Eh,
So that's not a P.O. Box.
entonces, esa no es la P.O. Box.
That's a mailing address.
Esa es para la dirección para que le llegue su correo.
He advised he could get it both at a P.O. Box and at this address, Judge.
Okay, so 9321 Southwest 8th Terrace, Miami, Florida,
33174, Your Honor.
33174. All right, I'll have the clerk update the address. Does he need a number, does he need access to his phone or anything?
Le vamos a pedir a la secretaria que cambie la dirección y necesita acceso a su teléfono.
No.
Okay, thank you, good luck, sir, look for your court date.
Gracias, mucha suerte, señor. Le va a llegar la orden de comparecer por correo.
What page are we on?
We're on page 5.
Should I make an announcement, Your Honor?
Sure.
¿Alguien más necesita servicios del intérprete? Por favor, avisar a la persona que está a cargo.
Not at me.
Anybody at North Broward need a Spanish interpreter?
Oh, we're good, thank you.
Okay, thanks. Conti? No one at Conti needs an interpreter. Anybody at Paul Ryan? No one at Paul Ryan, we did Paul Ryan. Thank you so much. If something comes up, we'll call you again. Thank you.
Very good. Nice
Have
to
a
see
great
you.
day. See you at 1 probably. Kathy Williams Manganiello? Manganiello?
He's approaching, Judge. He's here at me.
All right. Good morning, ma'am. You have grand theft between $300 and $5,000, $1,000 bond. Count 2 is dealing in stolen property, $3,500 bond. You do have 2 probation violations. You have no bond holds. You are going before your division judge, Judge Tim Bailey, August 27th at 9 a.m. You're going to be held no bond on those 2 charges. Count 5 is false info, owner info pond items, $300 or more, $3,500 bond. So it's a total of $8,000 in bond on counts 1, 2, and 5, and 2 no bond holds. The court does find probable cause. Court's going to order no return, ma'am, to the target located at 1200 South Federal Highway, Deerfield Beach, Florida. Ma'am, I want to make sure you hear me. That's okay. No return, ma'am, to the target, 1200 South Federal Highway, Deerfield Beach, Florida. If you go back there, you'll be arrested. Do you understand?
Yes, ma'am.
All right. Is your mailing address 900 Northeast 12th Ave, Pompano Beach?
No, ma'am.
What's your mailing address, ma'am?
461 Northwest 40th Street, Pompano Beach, Florida, 33064.
Let me read it back to you, just so I know I wrote it down right. 461 Northwest 40th Street, Pompano?
Yes, ma'am.
All right. What say you, defense?
Judge, considering she's being held no bond on probation, she's going to have to go in front of Judge Bailey anyway. We'd be deferring any bond modification requests for that time.
Okay, so court will make count 1, $999. Thank you. Okay, next one's gonna be Tisha Thomas.
Ms. Thomas is here, present, main judge.
Thank you. Ms. Thomas, you have aggravated battery with a deadly weapon, aggravated assault with a deadly weapon without intent to kill. Count 3 is criminal mischief, bond set at $500. Court does find probable cause. Court's gonna order no victim contact, direct or indirect, with the alleged victim with the initials JEJ. I want everybody to listen up. No victim contact, direct or indirect, means no contact in person, calling, texting, writing, nothing on social media, and no contact through third parties. That means no passing messages, whether you're in jail or not. Do you understand, ma'am? No victim contact, direct or indirect, with the alleged victim with the initials JEJ?
Yes, ma'am.
All right, thank you very much. What say you, state?
Your Honor, I'm gonna be requesting a $7,500 bond on count 1, $5,000 bond on count 2. She has no criminal history. My recommendation is based on the level of violence alleged in the report.
Hey, defense?
Judge, speaking of Ms. Thomas, I do not believe she'll be able to come up with that bond amount. If my math is correct, it's somewhere in the neighborhood of $13,000. As you heard the state mention, she has no prior contact with the criminal justice system. She has very strong ties to our community. She's 21 years old, been living here her whole entire life. She is a single mother, mother of 2 kids, ages 7 and 2. Right now, the 2 children are with her father, the children's grandfather. She is working. She's working at Krispy Kreme Donuts. She's been there now for about 3.5 months, making $9.50 an hour. Her grandfather, who's retired and elderly, along with she's going to be reaching out to her friends, are going to try and see what kind of bond they can come up with to help post Ms. Thomas's bond. We do realize the charges are, as far as the nature of the charges, Judge. So based on that, I'm going to be requesting a $2,000 bond on count 1, a $1,000 bond on count 2. I'd ask you to consider an ROR on Ms. Thomas's behalf on count 3, so that would be a total of $3,000. We're hoping that her family can come up with that and help her get out of here and still support her family, Judge, and that's what we're requesting.
Okay, no victim contact, direct or indirect, with the alleged victim JEJ, and maintain 1,000 feet. No firearms, ammunition, weapons, and surrender to your local law enforcement immediately. If any, the court does have a concern that someone was beaten with a bat. 7,500 on 1, 1,000 on 2, ROR on 3. Thank you, good luck to you. Nicole
Judge,
Figueroa, yes?
One last request, and I didn't mention this earlier.
Sure.
Judge, the $8,500 might be out of reach. Would the court consider lowering the bond with a combination of maybe having her be placed on pretrial release so that she'll be supervised and maybe her her family can come up with a little bit more money? So based on that, if Your Honor, we're inclined to lower the bond to, let's just say, to $5,000 on count 1. Would Your Honor also then consider placing her on pretrial release in exchange for her lowering her bond?
Your Honor, I could understand a modification if there's going to be a GPS, but frankly, given that Your Honor set the bond because you're concerned of the violence alleged, I don't think calling a couple times a week really is going to
No,
alleviate that concern.
GPS, he said.
I didn't hear GPS.
Didn't you say GPS, or you said pretrial?
I did, but that might be a good idea, Judge. If you could, I'm sorry about that. I just don't want her to lose her job and then basically spiral out of control where then her family, her 2 kids are homeless, and it's just a whole negative
I
spiral
understand.
down.
All right, so this is what I'll do, because she doesn't have priors, and I am concerned with the level of violence. I'll set bond at 5,000 on count 1, 1,000 on 2, ROR on 3. She's to maintain 1,000 feet at all times from JEJ, and no firearms, ammunition, or weapons, and she's to surrender any to her local law enforcement, if any, immediately upon her release. GPS open schedule. Thank you. So it's 5,000, 1,000, ROR. Thank you. Nicole Figueroa, please.
Bonded, Judge, bonded.
Thank you. James Allen Yusko? James Allen Yusko.
He's here at Maine, municipal ordinance, Judge.
Oh, all right, I'm sorry. We're gonna have to recall it when Mr. Shake gets back.
The city
Here you
public
go,
defender,
Ms.
hold on.
Patrice. Thank you. Juan Ramon Morales, please.
He's approaching, Judge.
Good morning, Mr. Morales. You have two capious traffics, $500 bonds each, 2 counts. Good morning. 2 counts, so it's $1,000 bond total. The court does find probable cause for your arrest. You do have a hearing August 30th. There for 2 driving while licenses suspended at, says 8:30 at, it looks like 11 a.m., Judge Diaz.
Judge, in speaking, Mr. Morales, he wishes for me to ask the court if you would consider resolving both these offenses in exchange for his no contest plea and time served.
Say that again? I'm sorry, I was reading an order.
We'd be asking if the court would consider resolving his case today. I did explain to him as far as the side effects of having 3 driving while licenses suspended within a 5-year time span and the court costs associated with resolving each one of these different case numbers. But he wishes to ask the court to resolve it.
Do we have a driving record for Mr.
And, Your Honor, I checked
Morales?
already.
Yes.
It appears this, if he pleads out these 2 cases, it will result in a 5-year suspension.
Is this his 3rd or 4th?
This would be 2nd and 3rd.
He had a habitual traffic offender in 10.
Yeah, I'm just looking at the one from.
Okay, as long as he knows, it's up to him.
I explained that to him. I had a conversation earlier when we were here sitting down, and I just finished explaining it to him right now again, Judge, and he still wishes to go forward on this.
All right, what's your offer, state adjudication, and?
Well, Your Honor, I can advise you, I'm looking at the offers that were documented previously.
Sure.
The offer on count 1 would be an adjudication time served. The offer that was documented on count 2 is an adjudication 15 days Broward County Jail because there was a crash in that case.
Okay.
Did the state say 5 days or 15 days?
1/5/15. There was a documented crash, he said.
Hold on one moment, Judge.
Says his license is revoked.
Judge, considering he's in exchange there's no contest plea, he's going to be resolving his case. There's not going to be any trial. He's going to be accepting responsibility. Would the court consider, instead of the 15 days on count 2, would the court consider 7 days on count 2?
Okay, court would do 10. I mean, he's a habitual offender in the past.
He wishes to accept the court's offer.
Okay, which one is the 10 days, state?
On count 2.
37916.
Okay, thank you. All right, raise your right hand. Do you swear and/or affirm to tell the truth?
Yes, ma'am.
All right, is your name Juan Ramon Morales, Morales?
Yes, ma'am.
All right, put your hand down. It's my understanding through your attorney, Mr. Romero, you want to resolve your cases today?
Yes, ma'am.
Anybody forcing you to do this?
No, ma'am.
Are you under the influence of any alcohol, drugs, or medication?
No, ma'am.
Ever been treated for a mental illness?
No, ma'am.
Are you doing this freely and voluntarily? No one's forcing you?
No, ma'am. Wait.
Are you doing this freely and voluntarily? I asked you a yes and no question.
Are you doing this freely and voluntarily? Yeah.
It's yes or no?
If you don't want to do this, no one's forcing you. We can not do this. You understand? So I could resolve one and then I could bond out on the other one. We can ask the court.
I don't have a problem with that.
Yeah, I'd rather do that.
Okay.
Please. So we're just addressing count one, okay? Do you understand that?
Okay, sir, so with regard to case 17-19812 TC 10A, it's my understanding you wish to give up your right to a trial in that case for driving while license is suspended?
Yes, ma'am.
Anybody forcing you to do this?
No.
Are you under the influence of any alcohol, drugs, or medication?
No.
Ever been treated for a mental illness?
No.
You understand that if you get 3 driving while licenses suspended, within 5 years, your driver's license will be suspended, will be revoked, and your license will be revoked for 5 years as a habitual traffic offender. Do you understand that?
Yes, ma'am.
And this could be your 3rd. We could all be wrong. Do you understand that as well?
Yes, ma'am.
Okay, understanding everything I explained to you, you want to plead guilty, not guilty, or no contest to driving while licenses, suspended driver's license, first offense, case number 17-19812 TC 10A.
No contest.
You're doing this for, I'm sorry, and you've had enough of time to talk to Mr. Romero?
Yeah.
Do you feel your no contest pleas in your best interest?
Yes, ma'am.
Court's going to accept your plea, find that it's freely and voluntarily entered. Court has reviewed the court file and finds probable cause for the plea. Adjudication, time served, $293, and court costs 6 months to pay. Partial payments are accepted. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. Thank you very much. Good luck to you. Okay, we're going to go on. Hoel, Hoehl.
No problem.
With
Thank
pleasure.
you. Okay, sir, you have possession of cannabis, 20 grams or less, $100 bond. Count 2 is disorderly conduct, brawl, fight, corrupt, public moral decency. There's no bond attached to it. The court does find probable cause. What say you, defense?
Your Honor, I'm going to ask you to release Mr. Hull on his own recognizance. He lives in Dania. He's had the same job for the last 6 years. From what I understand, he has no prior contact with the criminal justice system that's of note. And he'd like to see about the possibility of coming back to court and getting maybe some type of diversionary program or get the case dismissed against him.
This is mailing address 4830 Southwest 28th Terrace, Dania Beach.
Yes, ma'am.
What say you, state?
It's fine, Judge.
Okay, ROR, go ahead.
Just ask, no return to this, listed location.
Sir, no return to 2822 Griffin Road in Dania Beach, Florida. Do you understand?
Yes, ma'am.
Okay, look for your court date.
Good luck.
Thank you.
You're welcome. Keivith Wilson, please. Oh, we'll call that again. Sorry. Bradley Consolo. Mr. Wilson, we have to wait till your attorney comes. Okay, Mr. Bradley Consolo, good morning.
Good morning.
How are you?
I'm good, thank you.
Okay, please state your name, first and last, and spell your last name.
Shannon Consolo, Consolo.
Okay, and your relationship to Mr. Consolo?
I'm his mom.
Okay. All right, so Mr. Consolo, you have possession of drug paraphernalia. There's a $100 bond. Court does find probable cause. It's a capias. He does have a court date coming up, August 27th at 10 a.m. So what say you, defense?
Judge, we're going to be asking the court to consider resolving his case today. My understanding is he was serving a state prison sentence. His EOS date is today, so that will be complete. This is, I believe, the only outstanding matter he has. He wishes to accept the state's offer.
Is there anything you'd like to add?
That would be great if we could resolve it today.
Okay, perfect. All right, sir, raise your right hand. Do you swear and/or affirm to tell the truth?
Yes, ma'am.
All right, your name is Bradley Consolo, Consolo?
Yes, ma'am.
Consolo.
Yes, ma'am.
All right, it's my understanding you wish to give up your right to a trial?
Yes, ma'am.
Anybody forcing you to do this?
No, ma'am.
Are you under the influence of any alcohol, drugs, or medication?
No, ma'am.
Ever been treated for a mental illness?
No, ma'am.
How do you wish to plead to possession of drug paraphernalia? Guilty, not guilty, or no contest?
No contest.
Feel that pleading no contest is in your best interest, sir?
Yes, ma'am.
And you've had enough of time to speak to your attorney, Mr. Romero?
Plenty.
Okay. Court's going to accept your plea, find that's freely and voluntarily entered. Court has reviewed the court file and finds probable cause for the plea. Adjudication, time served, $293 in court costs. I'll give you 6 months to pay. Partial payments are accepted. If you don't pay, your driver's license, I'm sure Mr. Romero explained it to you, your driver's license will be suspended. It'll affect your credit, and then you'll have a $25 late fee. And guess what? If you're driving while your license is suspended and your officer pulls you over, you'll get arrested. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. You're done with this case. You'll be released probably in 6 to 8 hours. Thank you.
Thank you. Good luck, sir.
Okay, thank you. Good luck. Romeo Carte?
Romeo Carty is here, President Manager.
Okay.
Judge, he declined the services of public defender. I'm being advised.
Okay, Mr. Carte, or,
Yes, ma'am. Ma'am, I just bonded out of jail. They never sent me a court date in the mail, so the cops stopped me in Fort Lauderdale. They put me in the car.
okay,
They called,
sir,
they let
this is the
him out,
problem
just
with
got me.
representing yourself. The
Oh,
problem,
no, I just...
sir, let me just tell you a couple things. You have the right to remain silent. Anything you say or do can and will be used against you. Do you understand that?
Yes, ma'am.
All right, and the problem, you can represent yourself, but the problem with representing yourself is that you might talk
I
about,
want to represent myself.
you want the public defender?
Yeah, yes, ma'am. I need public defender. Yeah, I didn't...
Okay, one, he declined. I guess he's changing his mind. I believe he also had another attorney. Who's Mr. Weisberg?
No, that's my public defender.
Okay.
Adjudication, it says ADJ.
No, cause I saw withhold right here. You had this stuff here. You
Oh,
had
no,
both.
that must have got attached to it.
Okay.
Thank you.
Okay.
That was the last gentleman, right?
Yes,
For the possession of drug paraphernalia?
right.
Yeah, adjudication time served, $293 in court costs, 6 months to pay for it.
Thank you. I just saw both. Thank you.
Okay, thank you.
Judge, in speaking with Mr. Carty, because he's been speaking to me for quite a while this whole morning, he never received notification from the court. He's telling me he never voluntarily absented himself from court proceedings. In fact, from what he's telling me, every time there's a court date, he knows about it, he's going to come to court. So based on that, Judge, he's asking me to ask the court if you would consider an ROR on this matter.
No, not based on the nature of these charges. He's going before Judge Pohl, 8/24, in 2 days at 9 a.m. Bond set at $500. Thank you.
Hey, ma'am, can I ask you one question?
Sure.
I'm out on bond right now for a felony charge that I went to court for, and this misdemeanor case, they never sent me a court date in the mail. That's what I'm telling you. That's why I'm in jail right now, because they messed up in the computer saying, you know what I mean? All I did, they didn't send me a court date in the mail. That's why I'm asking for ROR, because they didn't send me nothing in
Dave,
the mail.
what's your
man.
position?
Your Honor, I think this has to be brought before Judge Pohl. It was his capias. I think Judge Pohl has to make the determination how to proceed.
Well, let's check his address. Let's see if the address is correct on his notice.
It says it was in custody.
It says he was in custody at the
No,
time?
it says, I'm looking at the notice of hearing. It says open court, in custody.
So he was given the notice in court?
I'm just looking at what Judge Pohl, what's checked off on the notice of
Mr.
hearing.
Romero, they're saying he got notice in court.
I went to court. I got a felony that I went to court for. They gave me a notice for the felony, but the misdemeanor, they never sent me a court date to my house for that. I'm going to court for the credit card charges, but they never sent me a court date for the misdemeanor. I got a court date for the felony charges. I don't have one for the misdemeanor. That's why I'm here right now.
Judge, in speaking to Mr. Carty, maybe what I can surmise is that he's also going to court on a felony offense in which he has advised he's been going to court. He hasn't been missing that court date. I'm assuming maybe because of the two pending cases, if what Mr. Lunder is true, and I have no way of doubt, I'm not doubting it at all. If he was given court notice in court, maybe he just got confused and just went to his felony court and he didn't realize he overlooked this court date. Bottom line is, if he's going to court on his felony offense, which is more serious, that common sense tells me he's not trying to miss this court purposely. It's something like an oversight.
Yes, sir.
And I'm not, and understand, I'm not saying whether he was or wasn't in court. I'm just going by what is on the notice of hearing.
You know what, I'm sorry, this isn't in custody, just based on the totality. He's gonna have to, I'm sorry, he's gonna have to go see Judge Paul August 24th. Thank you, sir, good luck to you. John Frederick Dunn. Is there a John Frederick Dunn, please?
Mr. Dunn, come on up.
Okay, Mr. Dunn, you have a driving while license is suspended. $1,000 bond has been set. What say you, defense?
Judge, in speaking with Mr. Dunn, he wishes to resolve his case today.
Okay, did you speak to him about the 3 driving while licenses suspended within 5 years, habitualization?
I did, Judge.
All right, state you have an offer?
I'm just checking.
Do we have a driving record? This is John Frederick Dunn, D-U-N-N. Thank you.
This could be a third, Your Honor, from what I see.
This could be a third.
Judge, he does realize it, and he still wishes to proceed forward.
Okay, raise your right, what's your offer state?
Well, Your Honor, because it's a third, it would have to be an open plea.
Okay. Okay, you swear and/or affirm to tell the truth?
Yes, ma'am.
All right, put your hand down. It's my understanding, Mr. Dunn, that you wish to give up your right to a trial?
Mr. Cardozo?
Yes.
Anybody forcing you to do this?
No, Your Honor.
Are you under the influence of any alcohol, drugs, or medication?
No, Your Honor.
Ever been treated for a mental illness?
No.
You understand that if you get 3 driving while licenses suspended within 5 years, this seems like it's your third, sir. Driver's License Bureau will revoke your license for 5 years as a habitual traffic offender. Do you understand that?
Yes, I can't win either way due to child support. I just paid $8,000 to get my license back, and they suspended it 3 days later, so I give up.
All right, but you understand, though, sir, that you have to answer my question. If you get, this is your third, the Driver's License Bureau is going to revoke your license for 5 years as a habitual traffic offender.
Yes.
And if you're driving while your license is suspended as a habitual traffic offender, that's a felony, sir.
Yes, Your Honor.
Okay, you understand the maximum penalty for this charge is 1 year up to.
May I have one moment to ask him one question, Judge?
Sure, no problem. Go ahead.
Judge, when speaking to Mr. Dunn, I inquired a little bit more as far as the circumstances. I believe part of the problem that led for him missing his court date was that he is homeless. He lost his job. As you can see, it's all like basically financial hardships. He did advise me the only good news right now is that he just managed to get a new job. So hopefully he wanted to try and build up to get back current on his child support and eventually try and correct his license. I understand, Judge, that another judge issued this capias. I wanted to know if the court would be willing to consider releasing Mr. Dunn, ROR considering, like the backstory I just informed, Your Honor of. Because if this is gonna lead to a 5-year revocation, and if there's some way to try and see what he could do as far as if it's a monetary reason why his driver license is suspended, maybe he can avoid all that, and
Well,
that's what I
he
was just getting to
said
myself.
that he just paid $8,000, and I don't know if that resolves his child support. I don't see that indicated anywhere. And this driver's license was, as of August 22nd, this morning.
There's still, even though he paid all that monetary amount, I believe there's still some outstanding balance, but with this new job, he should be able to take care of that, Judge.
What's his new job? Where is it? When does he begin?
Let the,
The job started 2 days ago, Your Honor. It's right here on 14th Street Causeway here in Pompano. I'm doing the tile floor, the whole renovation. I'm an electrician, plumber, and all that. I just started. I'm in the process of pulling permits, and I got arrested yesterday. So actually, I have my wife out there trying to, tell the guys that, hopefully I'll be out in a couple of weeks or this and that, and, making up stories just to try to salvage to save this job. If I lose this, Your Honor, I'm at wit's end. I don't know what else to do. If I can just, I know I've been in the system a lot, but I paid a lot. I'm trying here. It's not like I'm just running around not trying to do anything, I'm working, and I just need a little break. This child support, my son's 18 years old. It's not even, this is old stuff because the state took them from me in Kansas over some dumb stuff. And it's like I pay, and I still get suspended. And it's like, I don't know what to do anymore, to be honest with you. That's why I said I'm about to give up. I can't do nothing right. It's like I pay, and nothing works. I get up every day, and it's like, Jesus, why do I even wake up anymore, I'm sorry, Your Honor. I just don't know what to do, I don't have no money for bond. And that's the reason I'm to the point I'm willing to sacrifice my license for 5 years just so I can get out. Because I have a wife out there just sleeping in a car that I don't even know they got impounded. And it's like, if I can't get out today, then yes, I will take the plea to lose my license just so I can get to work at least.
But it's a difficult situation, Judge, and that's why I apologize for interrupting, but when I heard the cracking of his voice and then I kind of wanted to inquire more with the child support, that's why I brought it to your attention.
State?
It'd be one thing if the support was the only reason why his license was suspended. Multiple failures to appear, PIP cancellation. There are other reasons why his license is currently suspended.
I don't know what to tell you, Judge.
And again, all he has to do to avoid this type of situation is not drive.
Or show up for court.
That too.
Do you have a mailing address?
No, Your Honor, I have an email, but I can, I don't.
How about your
Mom?
your mom anywhere? Yeah.
Yeah, I got a mom.
There you go. That's mailing.
Yes, Your Honor, I have a mailing address.
What is that, sir?
P.O. Box 1004, Kenansville, Kenansville, North Carolina.
Okay,
Zip
K-E-N.
Kenansville, Kenansville, North Carolina, NC 28349. And her name is Marie Dunn. That's my mother.
Okay, sir, this is what I'm gonna do. I'm gonna put you on pretrial release. If you don't show up and you come back here again, I'll remember you. You better have your bond money ready, you understand?
Your Honor, thank you so much for your consideration. I won't let you down. I will show up to court.
It's up to you, sir. You have to report within,
Across the street.
you have to report within 24 hours of your release.
Yes, Your Honor.
Thank you, sir. Good luck to you.
Thank you.
Jonathan Ruval Caba.
Mr. Ruvalcaba, how do you pronounce your last name? Ruvalcaba is here present, Judge.
Okay, thank you. All right, Mr. Ruvalcaba, you have two capious misdemeanors, $500 bond each, possession of cannabis under 20 grams, and possession of drug paraphernalia. What say you, defense?
Judge, Mr. Ruvalcaba wishes to resolve his case. In exchange for his no contest plea, we'd be asking the court to consider withhold adjudication, take judicial notice, time served.
That'd be the state's offer on both counts.
308 on the possession of marijuana, and 293 court costs on the possession of drug paraphernalia. 6 months to pay.
He wishes to accept the state's offer, Judge.
Yes, I have it. So case, count 1 is 153720 MM40A, and count 2 is 153720 MM40A. Raise your right hand. Do you swear and or affirm to tell the truth?
Yes.
All
Yes, Your
right,
Honor.
put your hand down. Is your name Jonathan Ruvalcaba, Ruvalcaba?
Yes, Your Honor.
Okay. It's my understanding you wish to give up your right to a trial, sir? You want
wish to
it?
give up right to a trial? I have no idea what that means.
All right,
Do you
let
want
me
to try? Do you want to fight this or not fight it? Yeah, I'm gonna fight it, like, cause I didn't do anything, but I want to get out today. That's what I'm saying. Judge, in that case, Judge, I don't feel comfortable resolving it today from what he just said.
Please,
Judge, I would ask you, Judge, considering this is a cannabis offense, the date is a 2015. I'd ask Your Honor to consider an ROR on these, on this cannabis offense.
Here's the thing, he doesn't show up.
I will show up.
I mean, so for 3 years, he hasn't shown up.
I was unaware of it. When I went to court,
Frankly,
I went, and then they told me that it's all right, because I was going to work, and then the officer was not there.
I mean, Your Honor, frankly, we're trying to avoid the situation which we now have, where we have to dismiss warrants over a certain age to, you know, I'm hoping to avoid another 3 years, you know.
What's your mailing address?
My mailing address, JNATH, or my house address, 1710 Southwest 41st Ave.
Do you own or rent?
Do you own or rent? I rent.
How much is your monthly rent?
I pay $500 a month. Cause I rent a room.
What do you do for a living, sir?
I work in Lime Mexican Grill and Broward Mall as a runner.
All right, I'll put him on pretrial supervision, but he's got to report within 24 hours.
Yes, sir.
And he's got to report once a month in person. Call in 2 times a week. Thank you, sir. Good luck to you. Donald Bianculli?
Did you call for Giovanni Chisholm?
No, Donald Bianculli. Bianculli, Cully.
Good morning, Your Honor.
Good morning. He has
How you doing?
Good, fine, thanks for asking, sir. You have trespass, failure to leave property upon order by owner. Court does find probable cause. Court is going to order, sir, no return to the Sawgrass Mills Mall at 12801 West Sunrise Boulevard. If you go back there, sir, you'll be arrested, so don't go back there, okay?
I'm going home. I'm going home.
Well, hopefully home isn't the Sawgrass Mills Mall, because you'll be arrested if you go back there, okay? All right, so what say you, Mr. Romero?
Judge, he advised me he wanted to resolve his case.
Date?
Offer be 5 days, Your Honor. Mr. Bianculli has come through this division many times, and it's usually for trespass. He's trespassed at Sawgrass Mills multiple times in the past and other locations.
Okay, so this isn't his first trespass at Sawgrass Mills. 5 days, Broward County Jail. credit for time served, no return to the Sawgrass Mills Mall. If he doesn't have a place to live, he can potentially go to the CRC.
Judge, he wished to accept the state's offer for 5 days. I did was talking to him about the CRC as far as, but he advised me he has a place to stay. So at this time, we're just going to be resolving his case.
Someone being
Okay, raise your right hand, sir. Do you swear and/or affirm to tell the truth?
Yes.
All right, is your name Donald Bianculli?
Yes, ma'am.
Bianculli?
Yes, ma'am.
It's my understanding through your attorney, Mr. Romero, that you want to resolve your case today and give up your right to a trial?
I resolved my case here.
Do you wish to give up your right to a trial, sir? Do you want a trial or do you want to fight your case?
No. I just do my time.
All right, here's the question. Do you want to give up your right to a trial, sir?
No. Let me explain it to him. Okay. Judge, I explained to him the court may inquire.
Okay. Sir, do you wish to give up your right to a trial, meaning you don't want a trial, you want to admit to the charge today?
Yeah, I'm gonna admit to the charge.
You want to give up your right to a trial?
No. At this point, I don't feel comfortable going forward with this. I'd ask you to consider, releasing ROR on this offense, Judge.
Does he have any money in his property?
Judge, it's $5. I think it's gone right now.
What's his mailing address? I have 5100 address. Would this be appropriate for Judge Wren, maybe?
Judge, he doesn't have the address memorized.
Would this be appropriate for Judge Wren, maybe?
It may. Yes, Judge.
All right, I'm going to leave the bond in place, and I'm going to transfer this to Judge Wren. And if not, then Judge Wren can just send it to a regular division. State?
I'll notify her judicial assistant.
All right, sir, so you'll see Judge Wren in a couple days, probably Thursday?
I think tomorrow they should be
Yeah,
able to.
probably tomorrow.
Yes, Judge, I
Good
think
luck.
that's the correct decision.
Okay,
based
thank
on
you.
what I'm seeing in front of me here.
All right,
Thanks, Judge.
that's why it's good to ask questions a lot of times. Richard Nichols. Oh, that's an MO, my bad. Christopher Webb.
Mr.
Christopher
I've
Webb.
been informed is in regular court, 6160, Judge.
That's Judge Gottlieb, probably. All right, so let's, pardon?
Well, what I was gonna advise you, I think he's probably in front of Judge Merrigan. Both these cases are in Veterans Court.
Well, it says 6160, Judge Merrigan's, I thought
I don't-
over in the North Tower. Am I wrong?
I can tell you, it says, when you look in Odyssey, it's another one of those situations where it says in the top, Gottlieb, but the cases aren't in Veterans Court, so.
Okay.
I would just ask if the court, would pass it through.
Well, let's reset it, because he has no bond holds for petty theft and trespass, so,
And I checked, those no bonds were set by Judge Merrigan in Veterans Court.
No, I understand, but let's reset it for 1 o'clock just to make sure, okay? I don't want someone sitting in jail on those charges. Okay, Chucky Wesley, please. Yeah.
Mr. Wesley is approaching, Judge.
Good morning, Mr. Wesley. You have false ID given to a law enforcement officer. $100 bond, count 2, is a capious misdemeanor for operating a motorcycle without a valid license. Court does find probable cause. Bond is set at total of $100 each, $100 each count, so $200 total. Court does find probable cause for your arrest, sir. What say you, defense?
Judge, in speaking Mr. Wesley, he wishes to resolve his case today.
State?
Offer is withholds on 1 and 2. Court cost on both.
He wishes to accept the state's offer, Judge.
Are you gonna hire anyone if you want a public defender?
Raise your right hand. Do you swear and/or affirm to tell the truth, sir?
Yes, ma'am.
Put your hand down. Is your name Chucky Bernard J. Wesley, Wesley?
Yes, ma'am.
It's my understanding you want to give up your right to a trial?
Yes, ma'am.
Anybody forcing you to do this?
No, ma'am.
Are you under the influence of any alcohol, drugs, or medication?
No, ma'am.
Ever been treated for a mental illness?
No, ma'am.
Okay, how do you want to plead to false ID given to a law enforcement officer and operating a motorcycle without a valid driver's license? Guilty, not guilty, no contest.
I'm pleading no contest.
Feel that pleading no contest to both charges is in your best interest?
Yes, ma'am.
And you've had enough of time to talk to your attorney, Mr. Romero?
Yes, ma'am.
All right, court's going to accept your plea, find that's freely and voluntarily entered. Court has reviewed the court file and finds probable cause for the plea. Withhold of adjudication on each count, court costs of $293 on each case. 6 months to pay, partial payments accepted. Court takes judicial notice of time served in the Broward County Jail. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, sir, one will be appointed. Thank you, good luck to you. You're done with this case except for paying your $293 in court costs. Thank you. Damian Johnson, please.
Mr. Johnson, come on up, please.
Good morning, Mr. Johnson. You have possession of cannabis, 20 grams or less. You have a capious bond set at $500. Court does find probable cause for your arrest. What say you, defense?
Judge, in speaking Mr. Johnson, I believe he has a clean record. He's an Army veteran. He's a registered voter. My understanding is, I believe, he said he didn't get notice, and he did acknowledge, I believe it was partly due, he didn't update his change of address with the clerk's office. I did advise him how to go about doing that. He will be doing that, Judge, and we're going to be asking Your Honor to consider releasing him ROR on this cannabis offense.
That's fine.
Okay, ROR, give me the new address, please.
Let the judge know your address, sir.
My new address is 6000 Palm Trace Landings. It would be PALMTRACE Landings Drive, apartment 106, City, Davie, Florida, zip code 33314.
Okay, sir, I'm gonna have the clerk update your address. I'm gonna release you on your own recognizance. This is a 2016 case. Please do not miss court, sir, okay? Next time, you're not gonna be ROR'd if you don't show up. Good luck to you. You can also go to Broward Clerk, sir. You can also go to browardclerk.org, call the public defender's office, and, you can check online through the browardclerk.org. Thank you, sir. Good luck to you. Jim Alsonot? Pardon?
This is the ordinance, Your Honor.
Oh, I did it again. Okay. Daniel Berta.
No problem. Yeah, but your attorney's not there yet.
Okay, Mr. Berna, how are you, sir?
Okay, and yourself?
Fine, thanks. You have 2 ad charges dealing in stolen property and false ownership info of a pawn item Bond set on count 1 at $3,500, count 2, $1,000, total of $4,500. Court does find probable cause. What say you, defense?
Judge, Mr. Berta has a $15,000 bond on count 1,
Okay.
$1,000 on 2 and 3, a $3,500 bond on count 4. Are you gonna be able to make these bonds, Mr. Berta? Is there any way that's gonna happen?
No, sir.
How long have you been living in South Florida?
All my life, 37 years.
How long have you been living where you live now?
About 9.
Are you working?
Not at the moment, sir.
Who do you live with?
My grandmother, I'm taking care of her. She's going through cancer and radiation right now.
He's unable to make the monetary bonds as set, Judge. I know the other counts aren't in front of you, but perhaps you can grant him some relief on counts 5 and 6.
Okay, so tell me what it is you're asking for.
I'd be asking for a $500 bond on each count.
State?
Your Honor, I'd ask that the bonds be kept in place. He's scheduled for arraignment next week, a week from today before Judge Garcia Wood. These allegations, the proceeds connected to these allegations were taken from a home burglary that he has the $15,000 bond.
But he does have a $15,000 bond, right?
That's count 1, yes, Judge.
All right, sir, is your mailing address 172 Newport K, Deerfield Beach?
Yes, ma'am.
Is it Newport something else or just?
Newport and then the letter K.
Okay, $500 each count. Thank you, sir. Good luck to you.
Thank you.
You're welcome. James Connor? James Connor, please.
Judge, he's present here. He declined the service as public defender.
Okay, Mr. Connor, you understand that you have a right to an attorney if you can't afford one?
Yes, ma'am.
Do you have a
Yes, ma'am.
private attorney or you want to represent yourself?
No, I have a private attorney.
Who's your private attorney, sir?
Adam Rosen.
Did you hire him? Does he know you're here?
Yeah, he's worked with cases before me. He knows I'm here.
All right, can you call up Mr. Rosen, somebody?
Initial here.
All right, sir, we'll recall your case. Have a seat. Curtis Hughes. Mr. Hughes, good morning, sir. You have aggravated assault with a deadly weapon without intent to kill. Need to talk about bond. Count 2 is touch or strike battery. Court does find probable cause. Court's going to order no victim contact, direct or indirect, with the alleged victim in the case with the initials JAB. Do you need me to explain what that means, sir? No victim contact, direct or indirect? I do not mind.
No, I know what it means.
Okay, thank you very much. What say you, State?
Your Honor, I'm going to be requesting a $10,000 bond on count 1. I would note this incident was caught on video, and Mr. Hughes confessed post Miranda to committing the offenses. He has 2008 possession of alprazolam and possession of cannabis, 2008.
Okay, what say you, defense?
Judge, my understanding, as you heard, his contact with the criminal justice system is kind of dated. And my understanding, he was placed on probation because he was, I guess, a good candidate on supervision. He was early terminated. Having said that, Judge, he's self-employed. He does construct for a living. He's been doing that for about over 20 years. He makes approximately $300 per week doing that. He's 58 years old, been here since 1976. He lives here in Fort Lauderdale. He's renting a house. His monthly rent, the total rent is $1,500. He shares that expense with roommates. His share is $500. The only person that he can potentially call is his girlfriend, and he informed me his girlfriend is on disability. So from what the state mentioned, that's a bond that he's not going to be able to afford. Judge, we'd be asking you to consider setting a bond on count 1 of $2,000, along with the $1,000 bond. That would be a total of $3,000. That's what the defense would be requesting, Judge.
Okay, court's gonna set a $5,000 bond on count 1 And court will set a $100 bond on count 2. No victim contact, total $5,100. Thank you, sir. Good luck to you. Next one is Cedric Crump.
No problem, John.
Sure,
Sorry, Judge, what did you set the bond at?
5,100.
Thank you, Judge.
5,100 total. Hello, Mr. Crump, how are you?
Wonderful, how you doing?
Fine, thanks. Mr. Crump, you are charged with grand theft auto, $1,000 bond. Court does find probable cause. Court is going to order no victim contact, direct or indirect, with the alleged victim with the initials LDC. Do you need me to explain to you what that means, sir? I don't mind.
Yeah.
Means no contact in person, calling, texting, writing, nothing on social media, no message through third parties. That means no passing any messages to someone who passed to the alleged victim. And that's including even if you're in jail, okay? That's LDC. What say you, defense?
Your Honor, I'm going to ask you to consider releasing Mr. Crump on his own recognizance. He's been a resident of Florida for the last 10 years. He's been staying in the same location for the last 2 years. He lives with his wife and he has 2 children. He's been working at a call center, the same job for the last year. Also on the side, he's self-employed doing auto detailing and a cleaning business. And his last contact with the criminal justice system, I believe, was quite some time ago.
His mailing address, 1954 South State Road 7, apartment 104, North Lauderdale.
1754.
Yeah. Yeah.
Everything else
I
is
got it. I
correct in
found
the address, sir?
Yep.
1754, yeah.
1754 South State Road 7, apartment 104, North Lauderdale.
That's correct.
Okay, perfect. All right. State?
I have no objection to that.
Okay, ROR. So I'm gonna release you on your own recognizance, sir.
Okay.
Look for your court date. You can go to browardclerk.org, or you can contact the public defender's office.
Thank you very much.
Don't
Thank
miss court,
you.
man.
Freddie Hall. Freddie Hall, please. Where's Freddie Hall?
He's here at Main, Judge. Hold on one
Okay, and
second.
after Mr. Hall is Mick Cleelano.
He's approaching,
Cleland.
Judge. He's all the way in the back. He's coming up.
Thank you. Okay, Mr. Hall, you're charged with, good morning, sir, you're charged with possession with intent to sell, manufacture, or deliver cannabis, $1,000 bond. Court does find probable cause. Your mailing address, 815, it says Hamville Road. Is it Hammondville or Hamville? Can't hear you.
Hammondville. I'm sorry.
Hammond?
Hammondville, right?
Yeah, Martin Luther King.
I understand, but they have just HAMM, it's OND?
Yes, ma'am.
Okay. And the rest of the address is correct?
Yes, ma'am.
All right. Okay, what say you, Mr. Romero, $1,000 bond?
Nothing to add at this time, Judge.
All right, clerk to update the defendant's address to the proper street name, Hammondville Road. Thank you, good luck, sir. Look for your court date. Timothy McClellan.
He's here at Main.
Good morning, Mr. McClellan. You have grand theft. You have grand theft between $300 and $5,000, $1,000 bond. Counts 2 and 3 are the same. Possession of forged Arthur bill or promissory note, $1,000 bond each. Court does find probable cause, sir. Court's going to order no victim contact, direct or indirect, with the alleged victim with the initials TH. Do you need me to tell you, sir, what no victim contact, direct or indirect means? I don't mind.
No, you don't.
Okay, what say you, defense?
Judges, bond was posted on count 1 and 2
Yeah.
already,
I'm showing it's posted on 3 also.
and it's probably posted on 3 because the bond was coming back.
Sheila, I saw in BSO pics it was on all three. Okay.
What, did I hear his bond was posted?
All right, please say it again, Sheila, and turn your mic on, please. Thank you.
His bond is being posted.
Beautiful, then nothing to request.
Thank you. All right, let me just check his address. 5800 Lakeside Drive, apartment 1101, Margate.
Yes, ma'am.
Thank you. Look for your court date, sir. Good luck. Lee Thomas. Lee Thomas. And after Mr. Thomas is Clayton. Okay, Mr. Thomas, you have petty theft from a merchant, third subsequent offense. $1,000 bond. Count 2 is possession of drug paraphernalia, possess and/or use. No bond required in that. Total is $1,000 bond. Court does find probable cause. Court is going to order no return, sir, to, is this the Dollar Tree or Walgreens?
Walgreens.
Because it has Dollar Tree. Oh, he was outside the Dollar Tree. Okay, sir, there's no return to the Walgreens at 3895 West Broward Boulevard in Fort Plantation. Do you understand?
Yes, ma'am.
If you go back there, sir, you'll be arrested.
Judge, this being Mr. Thomas, unfortunately, he's not gonna be able to afford to post that bond. He's not working at this time. He lives with his elderly mother. Lives locally here in Fort Lauderdale, been here his whole entire life. Judge, Mr. Thomas is requesting to be released on pretrial release.
Okay. 3860 Northwest 8th Court, Lauderhill.
Is that your address? Judge? That is correct, Judge.
State.
I have no objection.
Okay, standard pretrial supervision. Sir, you're gonna have to report within 24 hours of your release. You're gonna have to call in twice a week and report once a month. If you fail to do any of that, you're gonna be arrested. You understand?
Yes, ma'am.
All right, sir, thank you so much. Good luck to you. You can also ask, sir, you can also ask pretrial services for your court date if you don't get it in the mail, okay?
Okay.
Thank you. Favoris Clayton, please. You're welcome.
Then you report tomorrow morning before noon time. Good luck, sir.
Okay, Mr. Clayton, you have possession of MDMA, ecstasy, $1,000 bond. You do have an out-of-county hold for a felony, which isn't for magistrate, which is kidnapping, robbery by sudden snatching, and domestic battery. Court does find probable cause on the MDMA, $1,000 bond, and for your arrest for the out-of-county hold, which actually is not for magistrate. What say you, defense?
Judge, as you can see, I believe he has an Palm Beach out-of-county hold on a more serious offense, which has a no bond hold attached to it. On this drug offense, would Your Honor consider an ROR so Palm Beach can come and pick him up?
And Your Honor, we'd ask that you keep the bond at $1,000. As you see all the time, Palm Beach can have prepared transport orders to have him brought up there, even if he's being held here.
$9.99. Thank you, sir. Good luck to you.
Yes, Judge.
Tyrese Lester. Tyrese Lester.
Mr. Left, come on up.
Are you Tyrese Lester?
Yes, ma'am.
All right, you have attempted murder, second degree, with a deadly weapon. Court does find probable cause. It says bond is set at, it has $10,000.
Yes, Your Honor, but I am going to be requesting a bond increase.
Okay? Go ahead, State.
Thank you, Your Honor. I'm going to be requesting a $100,000 bond, pretrial release with a GPS monitor. One, I would note the strength of the evidence in this case. I'm very concerned about the level of violence alleged in this case also. The allegations being that Mr. Lester first got into a verbal altercation with someone on a bike because of where he was riding his bike, tracked him down and attacked him at a gas station. When the man tried to just get away from Mr. Lester on his bicycle, Mr. Lester followed him, drove from behind, and struck him with his vehicle, launching him into the air. Your Honor, this is corroborated by two independent witnesses who both had the same version of events, that Mr. Lester's actions were intentional, that they believe he only stopped because they showed up and Mr. Lesser noticed that they were there, and that they believed if he continued, that he would have actually killed the alleged victim. And I would just note specifically, one of the witnesses visually estimated that Mr. Lester's vehicle was driving about 30 to 40 miles per hour prior to impact, and that he never applied the brakes before striking the victim.
Bent?
Judge, I'm gonna ask you to leave the bond in place, and this is the reason why. I believe Mr. Lester has no prior contact with the criminal justice system. He lives in Okeechobee. He lived here with his mother. My understanding is that Mr. Lester has been in contact with, I believe, Detective Heath, one of the detectives associated with this case. In their ongoing talks, Mr. Lester agreed to turn himself in and basically met with the detective, came down from Okeechobee to turn himself in on this offense. He's 19 years old, been living in Florida his whole entire life. Right now he's not working, he's going to school. He goes to a school called Home Health Aid. He just started, and he's going to be relying solely on his mom to post his monetary bond. I believe his mom works at a detention center, and right now what they're trying to do is even come up with funds, because right now they can't even meet the bond which is currently set at this time. I do understand the nature of the allegations. That's why I'm not asking you to reduce it, but considering the strong ties to Florida, Mr. Lester's not a flight risk, as evidenced by him actually speaking with the detective, turning himself in. I'd ask you to leave the standard bond in place at this time.
Anything further, State?
No, Judge.
The mailing address 6120 Northeast 72 CC Okeechobee.
Yes, ma'am.
Is that where he lives?
Yes, ma'am.
Correct, with his mom. That's where he had to travel down from to turn himself in.
All right, Judge Coleman did set the bond at 10,000. I'm gonna raise it based on the allegations to 15,000. I also am gonna do standard pretrial supervision. And have Mr. Lester call in 3 times a week. Report once a month in person. He can go to the division judge and ask to seek for leave for that. He doesn't want to drive from Okeechobee. No victim contact, direct or indirect, with the alleged victim. State, what's the initials?
No, Judge. They are T.I.
P or T?
T.
Tango? No victim contact, direct or indirect, with the alleged victim with the initials T.I. Do you need me to explain to you what that means? It means no contact in person, calling, texting, writing, nothing on social media, and no contact through third parties. That's whether you're in jail or not. And I want you to maintain 1 mile at all times. Thank you.
You're welcome.
Your Honor, if I may interject,
Hold on. Yes?
we have a case from this morning's felony domestic violence docket up in the North Broward Detention Center.
Mm-hmm.
And I was wondering if we could deal with that today, perhaps at 1 o'clock or whenever you want.
Why 1 o'clock?
Well, whatever you want to do it, because we
We
don't
can
have any
do it,
paperwork
we can
on
do
it.
it today. I want to take Mr. Shade. He's been patiently waiting. So let's just get that done. Do you need that one signed?
We've all been patient.
Okay. We can do it, no problem.
But to tell them up in North Broward to hang on to her or bring her back at 1?
Yeah, hang
or-
on. Do I have the paperwork?
No. That's why I was saying 1 o'clock.
Where is the
'cause
paperwork?
I don't know. I imagine it went to Judge Cohen.
What's the name? I'll have Michelle run over and
Sure.
get it.
Its last name is Cummings, Cummings.
Okay,
Her first name is Quanisha, Quannesia. And
I'll have
her-
Michelle come down and she'll
Okay.
call over and I'll give her the name. Can you come down for a moment? Thank you. Bye-bye. Okay, Mr. Shade. So we're gonna take a break, Mr. Romero and Mr. Reedy. And if you, need a break. Okay. All right, first one is Maxine Scarlett.
Correct, Judge, it's on page 1.
Where are they?
They're in,
Thank you. And we'll take that DV case at, this morning, okay? We're just gonna have someone go, my JA, go over to
how are you,
Judge
Maxine?
Cohen and get the paperwork.
Can you hear me?
Yeah.
Okay, Maxine, would you like to take a time served plea today and get out of jail?
Yeah.
Okay. How are you feeling? You okay?
I'm not okay because I'm in a position now, sir. My husband died. And I'm not working. I don't have no money.
Okay, I'm not talking about whether you're working. How are you feeling? You okay?
Yeah, my husband died. I'm not working, and I'm homeless.
Okay.
Sometimes my son help me out, but he can't do much
Okay.
because he sir needs something to say, but he worked, but he can't do much.
Okay. Would you like to get out today, take a time served plea? There's gonna be court costs involved though.
Sir, but I don't have the money to pay the court cost.
Oh, well, you have plenty of time to pay. If you don't ever pay, it can turn into a civil lien at some point in time, but it could also affect your driver's license and or your credit, and you'll have a late fee.
Sir, I cannot drive. I never drive from the bond.
Well, then don't worry about your driver's license if you can't drive. You'll be good, okay? All right, so it'd be $78 in court costs on both charges. If you don't pay, there'll be a $25 late fee. If you don't pay those, it'll turn into a civil lien at some point in time, okay? And then that's it. So you'll plead no contest today, okay?
Yeah. How much I'm supposed to pay, sir?
You have 6 months to pay that off.
How much?
$78 per count.
All right, that's gonna be $156.
Yeah, 6 months.
6 months.
Thank you, sir.
You're welcome.
All right, raise your right hand. Do you swear and or affirm to tell the truth?
Yes, sir.
All right, your name is Maxine Scarlett, Scarlett.
Yes, ma'am.
All right, how do you wish to plead to trespassing, no lodging on city-owned property?
I don't know where I'm trespassing, and I don't know which place I'm trespassing on. I do not know where I'm trespassing.
It's on the city property, ma'am, in Hollywood.
This is back in 2017.
Where?
All right, Mr. Shade.
Judge, I'll call her in a second if we could.
Okay,
hop
let's
over
just,
to-
ma'am, go to the left, okay?
Okay, all right.
I'll call you
Wait
in a
one
second.
moment, we gotta take care of a couple cases. Mr. Shade's gonna call you on the phone. James Yusko.
Judge, it's page 9 for.
Mr. Yusko.
He's in the main judge.
Yes, Your Honor.
Hello, can you see your attorney, Mr. Shade?
How you doing, Mr. Yusko? So you have 2 open containers. Would you like to resolve those today to time
Withhold.
served?
I'm gonna do a withhold on these, okay?
So there'll be a withholding of adjudication, $78 in court costs, 6 months to pay. It'll affect your driver's license and credit if you don't pay that off, and you have a $25 late fee. Do you understand?
I understand you, sir.
All right, raise your right hand. Do you swear and or affirm to tell the truth?
Yes, Your Honor.
All right, your name is James Yusko, Yusko.
Yes, Your Honor.
Want to give up your right to a trial?
Yes, Your Honor.
Anybody forcing you to do this?
No, Your Honor.
Are you under the influence of any drugs, alcohol, or medication?
No, Your Honor.
You can put your hand down. How do you want to plead? Guilty, not guilty, no contest to 2 counts of carrying an open container.
No contest, Your Honor.
Court's going to accept your plea, find that's freely and voluntarily given. Court has reviewed the court file and finds probable cause for the plea. Withhold of adjudication on each count and court costs on each count of $78. I'll give you 6 months to pay. Partial payments are accepted. Court takes judicial notice of a time that you served in the Broward County Jail. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. You're done with this case, sir, except for paying your court costs. Make sure you pay them, okay? Thank
Yes, Your
you.
Honor. Thank you, Mr. Shea.
Keevith Wilson, please.
Mr. Wilson.
Keevith Wilson.
Yes.
Mr. Wilson, you have trespass private property, $50 bond. You also have a capias for possession of drug paraphernalia. $50 bond, total of $100 bond. Court does find probable cause for your arrest. What say you, Mr. Shade?
Mr. Wilson, would you like to get this taken care of today?
Yes.
Okay.
And I'm gonna appoint Mr. Shade on these cases, by the way.
Judge, it's gonna be a time served plea, $78 on both counts. That'll come out to $156. If you don't pay, it could affect your driver's license and or credit later on, and you'll have a $25 late fee. Do you understand?
Yes.
All right, raise your right hand. Do you swear and or affirm to tell the truth?
Yes.
Put your hand down. Your name is Keevith Wilson, Wilson.
Yes.
It's my understanding, sir, through your attorney, Mr. Shate, you wanna give up your right to a trial?
Yes.
No one's forcing you to do this?
No.
Are you under the influence of any alcohol, drugs, or medication?
No.
Ever been treated for a mental illness?
No.
How do you wish to plead? Guilty, not guilty, no contest, trespass, private property, and possession of drug paraphernalia.
No contest.
And you've had enough of time to speak to Mr. Shate?
Yes.
You feel that your, no contest plea in both cases is in your best interest?
Yes.
Okay, court's gonna accept your plea, find that it's freely and voluntarily entered. Court has reviewed the court file and finds probable cause for the plea. Adjudication, time served, each count, $78 in court costs, 6 months to pay. Partial payments accepted. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, sir, one will be appointed. Thank you, good luck to you. You're done with this case, except for paying your $78 in court costs. Richard Nichols. Richard Nichols, please.
Mr. Nichols.
Mr. Nichols, come on, step up, please. And after Mr. Nichols, we have Jim Alsonat. Okay, Mr. Nichols, you have a capias for an open container. Court does find probable cause, bond set at $25. Court withholding court costs. Mr. Shate.
Mr. Nichols, would you like to resolve this today? Would you like to resolve this today, Mr. Nichols?
Yes.
All right, if they could try to keep it down a little bit at the main jail. Mr. Nichols is having a little bit of a hard time hearing.
It's gonna be $78 in court costs. If you don't pay that, there's gonna be a $25 late fee. It could affect your driver's license and or your credit later on in life. Would you like to accept that?
Yes.
All right, raise your right hand. Do you swear and or affirm to tell the truth?
Yes.
Your name is Richard Nichols, Nichols?
Yes.
Okay, you can put your hand down. Sir, you want to give up your right to a trial?
Would you like to give up your right to a trial?
Why would I have a trial? It's just
I know, would you like to give up your right and take care of it today?
In order to plead of a charge,
I know, so you're giving up your right to go to trial if you're taking care of it today. Do you understand that?
Yes.
Okay. So
anybody forcing you to do this?
No.
Are you sir, I have to ask questions to make sure you're doing this freely and voluntarily and knowingly, okay? That's the reason for all these questions. So, are you under the influence of any alcohol, drugs, or medication?
No.
Have you ever been treated for a mental illness?
No.
Okay, how do you want to plead to open container? Guilty, not guilty, no contest.
No contest.
And you feel that no contest is in your best interest?
Yes.
Court's going to accept your plea, find that it's freely and voluntarily entered. Court has reviewed the court file and finds probable cause for the plea. Withhold of adjudication, which means no conviction, and court costs of $78. 6 months to pay. Partial payments accepted. Court does take judicial notice of a time that you served in the Broward County Jail. Make sure you write that on the paperwork, Madam Clerk. Okay, thank you. And you have 30 days to appeal, sir. You're done with this case, okay?
Okay.
Except for paying your $78. Thank you.
Judge, the next one, Jim Alston, maybe a Fort Lauderdale case with just a day-near arrest. You're done.
Okay, give me 1 moment.
Okay.
Call up Judge Cohen, tell me of their defendant. They're at North Broward. Can you go get the paperwork or meet her halfway?
Yeah.
Okay, Jim Alsonat, please. Want to handle it as a courtesy?
Fine,
He's
no
in a
problem.
trial.
Definitely.
Mr. Alsonat, North Broward. Okay, withholding court costs. Open container.
Mr. Alston, would you like to resolve your case today?
Yes.
Okay, it's gonna be time served withholding, is it what, Judge, what was it gonna be? Time served?
Adjudication.
Adjudication,
I mean
time served.
withhold.
Oh, withhold. Okay, and there's gonna be $78 in court costs. If you don't pay that, there's gonna be a $25 late fee, and it could affect your driver's license and or your credit later on in life. Would you like to accept that and take a no contest plea to that?
Yes.
Excellent.
All right, sir, raise your right hand. Do you swear and or affirm to tell the truth?
Yes.
You can put your hand on.
Okay, sir, it's my understanding that you wish to give up your right to a trial?
Yes.
Anybody forcing you to do this?
No.
Are you under the influence of any alcohol, drugs, or medication?
No.
Ever been treated for a mental illness?
No.
How do you wish to plead? Guilty, not guilty, no contest to carrying an open beverage or container in public?
No. No contest.
And you feel that this no contest plea is in your best interest?
Yes.
You've had enough of time to speak to Mr. Shate, an attorney who's covering for Mr. McLawrence?
Yes.
Court's gonna accept your plea, find that's freely and voluntarily entered. Court has reviewed the court file and finds probable cause for the plea, withhold of adjudication, and court costs of $78. I'll give you 6 months to pay. You have partial payments can be made. Court takes judicial notice of time served in the Broward County Jail. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. Thank you, and if we could appoint Mr. McLawrence and give him that order when he comes in. Thank you. All right, there's no other ones. Thank you.
Judge, we'd have to go back on Maxine Scarlett.
Yes.
Judge, I looked at the paperwork, Judge, it doesn't give me an address as to where, because it's a 17 case.
It's Hollywood.
No, I don't know, but she wanted the exact address as to where she's not allowed to go.
Oh, no problem. I'll have her pull it up. Can you pull this up, the reports? All right, and while you're doing that, I'm gonna, oh, Mr. Romero's not here. I mean, Reedy's not here. All right, so we're gonna take a break quickly. All right, so let's recall Mr. Shate, your client, Maxine Scarlett.
Yes, sir, I spoke to her over at North Broward.
Okay, let me get her back. Hello, ma'am, welcome back.
Yes, ma'am.
Okay,
You've had
Maxine,
enough of time to speak to your attorney, Mr. Shate?
did you have enough time to speak to me?
Yes, sir.
Okay, and I explained to you where you were not supposed to be, correct?
Yes, sir.
Okay, and we had a little conversation about possibly getting your bags back, right?
Yes, sir.
Okay, and would you like to try to resolve this today and plead no contest and get out later on this evening?
Yes, sir.
Okay, it's gonna be $78 in court costs, Maxine, and I understand
Nice.
you don't have a driver's license, so don't worry about that, but if you don't pay, it could affect your credit later on in life, okay?
Thank you.
Yes, sir.
And there'd be some late fees as well.
Yes, sir.
Thank you.
Okay.
Make 2 copies. Okay, raise your right hand. Do you swear and/or affirm to tell the truth? Raise your right hand. Do you swear and/or affirm to tell the truth?
Yes, ma'am.
Is your name Maxine Scarlett, Scarlett?
Yes, ma'am.
Mr. Shate, your attorney, has been telling me that you want to give up your right to a trial and plead guilty or no contest to the charge of trespassing and no lodging on city-owned property. Is that correct?
Mm-hmm.
You have to say yes or no, ma'am.
You have to say yes or no, Maxine.
Yes, sir. Yes, that's it, ma'am.
Okay. Anybody forcing you to do this?
No.
Are you under the influence of any alcohol, drugs, or medication?
I never smoke from a barn.
I'm sorry, repeat that?
I don't smoke and I don't drink.
Okay, don't smoke and don't drink, that's good for you.
Yeah.
So are
okay?
you under the influence of any alcohol or drugs, yes or no?
No. No.
Have you ever been treated for a mental illness that would affect your ability to understand what's going on here today?
I'm perfect.
Okay. And you understand that if you're not a U.S. citizen, a plea of this charge could result in deportation proceedings.
I'm a U.S. citizen. Miss.
Okay, then it doesn't apply to you then. All right, so you want to plead guilty or no contest to trespassing and no lodging on city-owned property?
I will not go back there.
Ma'am, you have to tell me how you wish to plead to those 2 charges. Guilty, not guilty, or no contest?
No contest.
And you feel that pleading no contest to these 2 charges is in your best interest to resolve this case today?
Yes, ma'am.
And you've had enough of time to speak to your attorney, Mr. Shate.
Yes, ma'am.
All right, court's going to accept your plea, find that's freely and voluntarily entered. Court has reviewed the court file, finds probable cause for the plea, adjudication and time served on each count, $78 in court costs each count, 6 months to pay, partial payments accepted. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. Thank you. Good luck to you, ma'am.
Please, can I get information of?
You'll get all that information.
Okay.
Okay, take care, Maxine.
Thank you.
Okay,
If you
Mr.
need me,
Rosses.
I'll be upstairs.
Your Honor, may I call a case?
Sure, give me one moment. It's Corner. How come I don't see it here? Here it is, Connor.
Page 14.
Okay.
Good morning, Your Honor. Adam Rosson on behalf of James Connor.
Okay, let's get him up. Michelle, if you could give a copy to Mr. Reedy and Mr. Linder. Okay, are you Mr. Connor, sir?
Yes, ma'am.
Can you see your attorney, Mr.
Rosson.
Rosson?
Yes, ma'am.
Okay, if any time you can't hear him, please let us know. Hit the mic, sir, okay?
Yes, ma'am.
Thank you. Okay, you are charged with 2 counts, dealing in stolen property. Bond set at $3,500 per count. Counts 3 and 4 are false owner info for pawn items less than $300. 2 counts, $1,000 each. And count 5, sir, is a probation violation. You have a no bond hold. Any objection to probable cause?
No objection, Your Honor.
Okay, court does find probable cause. Court, sir, is going to order no return to the Mako located at 4515 North Dixie Highway, Oakland Park, Florida. If you go back there, sir, you'll be arrested. What say you, Mr. Rosas?
Your Honor, on count 5, the violation of probation, I'm asking the court to set a bond on that. This is a bit of unusual circumstances. Mr. O'Connor started probation 2/22 of 17 for possession of cocaine. He very quickly violated with no-show and with a positive dirty urine. From that first no-show, which I believe was his first appointment, until he was picked up in November of last year, strung out on drugs. He's had a drug problem for 10 years. We had the violation of probation hearing. We resolved it in front of Judge McCarthy in December. Judge McCarthy sentenced him to December of 2017. She sentenced him to, I believe, he did the SAP program when he was in jail, 60 days of BARC inpatient, and 10 months of primary purpose. Mr. Connor is almost done with primary purpose. He's doing exceptionally well. If you look at him, he's healthy. He's gained weight. You should have seen what he looked like last fall in court. His face was sunken in. He was probably 20, 30 pounds less. He looked like a drug addict. He was a drug addict.
Congratulations, sir.
Exceptionally well. This happened during the time he was strung out on drugs. We didn't know about it. If we knew about it, it would have been addressed and dealt with at the violation of probation hearing, that we did in December.
Okay.
Mr. Connor found out about this just a few days ago. He turned himself in to police. So, Your Honor, for that, all of those reasons, I believe this is the 1 out of 100 on a felony VOP where the defendant actually does deserve a bond on this, based on everything.
And you're saying December 2017, he went before Judge McCarthy?
Yes, I represented him on that. He was in custody for about 4 to 6 weeks. We resolved it. He's doing exceptionally well. He completed the BARC IRT, the inpatient residential, 60 days, and he's almost done with primary purpose, which is 10 months. He's doing very well. The police officer that he surrendered himself to, he's actually was the one who turned him, or one who arrested him last year. They've become friends. The police officer checks up on him. Okay, the police officer has been encouraging him to stay the course. He has a family, he has children. The police officer is the one that said, "Hey, James, I did a random check, and you have this warrant that came out 3 or 4 days ago." He said, "Oh, this, I totally, this is what, I remember doing this when this happened, of course." And they coordinated a surrender, and he went in with his friend, with the police officer who took him in. So, Your Honor, this is that 1 out of 100, situation where I strongly believe he deserves it. He's doing exceptionally well.
State?
All right, just have 1 moment, please.
I have his address as 7616 Sunflower Drive, Margate. Says mailing address.
And, Your Honor, the other thing that should be noted, this happened in October. It seems as though it was pretty clear cut that it should not have taken this long for the warrant to actually be, out in the world. Right, but I'm saying I don't. Why was it not filed till 10 months later? When it seems pretty clear cut. This wasn't one where I believe there was DNA, or you get a hit 12 months later, Judge. So, whether that was the fault of the state or the fault of the police or just what happens, that as well, I don't believe should be held against Mr. Connor.
Okay, State, what's your position? I asked him if this was his address, and I didn't get a response.
I don't know if he thought you were speaking to
No, I
him.
know, 7616 Sunflower Drive, Margate. Can you get mail there?
Yeah, I get mail there, but I'm
That's
reside
fine,
at primary
that's
purpose.
fine, as long as you can get mail there.
Okay.
Okay, go ahead. The state attorney wants to speak privately with your attorney, okay?
Okay.
Did you read Cummings?
Judge, I have no objection to an ROR on the VOP. And
Okay,
I don't know if you, what about the other four?
Your Honor, I don't know if you'd be inclined to, reduce bond on the other four, or if,
okay, so tell me what it is you're requesting, and then, because it's $9,000 total.
right. Your Honor, if we can have it reduced to 5,000 total, I believe that's something that he'll be able to afford.
I'm fine with 1,500 and 1,500 on 1 and 2.
Okay, so we'll do 1,500 on 1, 1,500 on 2, 1,000 on 3, and 1,000 on 4. No return, sir, to the Mako. Good luck to you.
Yes, ma'am, thank you, Your Honor.
And an ROR on the VOP per the state and the defense.
Thank you, Your Honor.
Thank you, good luck to you.
We can call that domestic violence case anytime.
Hey, give
you
me
want,
one
Judge.
second, I'm just
Sure.
writing this, no problem. Actually, I have to read it quickly, so. All right, so let's take a break real fast. All right, let's call Quenisha Cummings, please. Sure. All right, good morning, Miss Cummings, how are you?
Good morning.
You were supposed to actually be before Judge Cohen for this case this morning, but because they didn't bring it to the courthouse, I'm gonna be handling it, okay? I just
Yes,
wanted to
ma'am.
tell you, you have the right to remain silent. Anything you say or do can and will be used against you. We do have Mr. Reedy, who's to my right here, who you spoke to earlier, I believe, and he is going to be representing you. He's from the Public Defender's Office. We do have a change of charge from burglary with assault or battery to aggravated assault with a deadly weapon. This is count 2. Court does find probable cause. Court is going to order no victim contact, direct or indirect, with the alleged victim in the case with the initials CB and QJ. That means no contact in person, calling, texting, writing, nothing on social media, and no contact through third parties. And in fact, the court's going to ask that you maintain 2,000 feet at all times from QB and QJ and their residence. Okay, State, what are you asking for on the ag assault?
Your Honor, I'm asking for a $15,000 bond. She allegedly broke into the home, pulled a knife on a juvenile. Law enforcement actually still saw her in the home with the knife in her possession when they arrived at the scene. In 2014, she was arrested for aggravated battery, great bodily harm, and 2 counts of aggravated assault with a deadly weapon. Those charges were domestic in nature. They were dropped. 2005, she was arrested for aggravated assault with a deadly weapon. That was domestic in nature as well. That case was dropped.
So I thought we had all of Ms. Cummings' charges here before the court this morning, but it appears that's not the case. It's just count 1.
It's just the change of charge, yeah.
Right, it's just the change of charge on count 1. I'm sorry, Ms. Cummings, we can't address the no bond hold on you on count 2. You're going to have to go in front of Judge Cohen for that.
He found proof evident presumption great already.
Right.
Or Judge Bristol did.
Right, but that's an issue, you can raise that again in front of Judge Cohen. Judge, I'd ask for a much lower bond on count 1. My understanding is that the house in question is her mother's house, the knife in question is a butter knife. The juvenile is her son, who has some special needs issues. I'd ask the court for a $5,000 bond on count 1. She can go in front of Judge Cohen and resolve or petition that court for bond on count 2. And it appears she has no criminal record. And she has lived in Florida for 10 years. She does have her father here. She was just starting a job when she got arrested. She has a place to stay in Dade County with her father-in-law.
All right, the court, thank you for your argument. The court is going to set the bond at $15,000. The reason being is, it says in the PC, the juvenile advised that Cummings does not live at the residence and broke the window to gain entry, and that Cummings attacked him with a knife and he tried to hold her back. So $15,000 on the ag assault, no victim contact, direct or indirect, and maintain 2,000 feet from the alleged victims and 2,000 feet from the residence. I am going to do a GPS level 2 on this count only, obviously. No weapons or ammunition, and surrender any firearms or permits. Okay? Thank you very much. Good luck to you, ma'am.
Good luck, Ms. Cummings.
Thank you.
Pardon? Okay.
Just let me know.
Do you have the initials? What's the initials on there? I have them on there. Madam Clerk? It's on the paperwork.
Let me give it back to you.
Okay, thanks. Here you go, Miss Patrice. I'll show you exactly where it is. Just has the juvenile's initials, by the way. Here you go. All right, next one we're gonna call is Marlon Hugh McDonald. Good morning. You have driving while license is suspended, third or subsequent offense, $750 bond. Court finds probable cause. Is your mailing address, sir, 1637 Northeast 31st Street, Pompano Beach.
Yes, ma'am.
Yes, Judge.
Hold on, let me just look at this for a second. Okay, defense, want to look at his driving record and then show of estate?
I have it.
I don't see where it's, oh, third, I'm sorry. My bad. Okay, what say you?
Judge, it's me, Mr. McDonald. He's just going to be requesting a phone order, and he'll be able to contact someone to post his monetary bond.
Okay, thank you very much. Good luck to you, sir. Mr. Reedy, if you could do a, Harold Watkins, please?
Mr. Watkins.
Here you go, Jackie. Mr. Watkins, you have burglary with assault or battery. Says 100, okay. So the court found PC previously for burglary with assault or battery, battery on an officer, firefighter, EMT, etc., resisting an officer or obstructing without violence, and petty theft, second degree, first offense. This was done on 8/21, 2018. Bond is set, it says no bond, it says 100,000 on 1, 10,000 on 2, 1,000 on 3, and ROR on 4. So the defendant is being brought back because he was on medical loan. The only reason it's set for 100,000 is when it was medical reset, the magistrate that day, I don't know if it was Judge Cohen or not, but they just put in for their notes the 10,000, the 100,000, 10,000, and 1,000 in ROR.
I couldn't tell you, Judge. It must have been done
Right
over-
here.
No,
He did it when he was reading it, so that's why they took the
Yes.
no bond hold. So in any event, state, what are you requesting on count 1, 2, 3, and we can leave 4 at ROR?
Your Honor, I am going to be requesting a no bond hold on count 1 upon a finding of proof evident or presumption great for first appearance purposes only, relying upon the probable cause affidavit. Does the court want a recommendation on 2 now, or do you want me to wait till you make a finding?
It doesn't matter, I'd like you to emphasize why you're asking for proof evident presumption great
Okay, well,
on count 1, please.
Your Honor, I'm asking for proof evident presumption great on count 1, first off, because this involves someone's home as opposed to a car.
Sure.
It appears Mr. Watkins just entered, as a stranger to the owner, just entered his home, 1 moment, the first time,
Take your time.
yes, broke into his home through his window and attacked the victim. When the victim was able to finally get him out of his home, Mr. Watkins then entered the home again and for some reason stole a pot. I would note that, and the victim was able to forcefully remove him from the home. I would note that a neighbor saw Mr. Watkins leaving the home. Additionally, as the victim kept track of Mr. Watkins while calling 911, even when law enforcement attempted to take Mr. Watkins into custody, he forcibly resisted. So I do have a concern. I also have concerns, and the reason I'm asking for no bond is I believe he has lack of ties to the community. I believe he is transient, so I have a concern that someone with such lack of ties to the community is.
Are we
just-
talking about proof evident presumption grade, or are we talking about ties to the community?
Okay, you can continue with that later.
No, Your
so go
Honor,
ahead.
I've made my argument for proof evident presumption great. I'll leave it at that.
All right, Mr. Reedy.
Because if we're gonna get into all of that.
No, I
which I don't
understand, I
mind
just-
doing, it's okay. I would object to the court making a finding of proof evident presumption great based on this probable cause affidavit. It appears the alleged weapon was a pot. The state has called no witnesses, introduced no evidence. Proof evident presumption great is the highest standard that we have in our criminal justice system, and for the state to come into court with a probable cause affidavit and ask the court to make that very high finding, I would submit, it has not been accomplished here today. I would ask the court to set bond in this case for Mr. Watkins and not make a finding of proof evident presumption great. If the court, over my objection, disagrees with me and does find proof evident presumption great, I would ask the court to exercise its discretion and set bond for Mr. Watkins.
All right, I am going to find proof evident presumption great. I have reviewed the probable cause affidavit, sir, filed in your case. And on count 1, I do find probable cause. Well, I previously found probable cause actually on 8/21/2018. We further find the proof of guilt to be evident or the presumption great. That's for today. You are to be held without bond on count 1 till further order of the court. This order is without prejudice, sir, for you to file a motion to set bond with your assigned division judge and request a hearing under State v. Arthur. As to counts 2 and 3, 4 will leave at ROR. What say you, defense? It's 10,000 and 1,000.
Judge, considering he's being held no bond on counts 1, he's gonna have to go in front of his division judge. However, the $10,000 on a third-degree felony is something that Mr. Watkins is not gonna be able to afford. Would Your Honor consider reducing it to $1,000 on count 2? But most importantly, Judge, we'd be asking you to sign an order allowing us to photograph the injuries that Mr. Watkins sustained as a result of his contact with law enforcement.
Sure.
It's fine.
I'm going to set the bond on counts 2 and 3 at $9.99 each, and I will sign a photo order. Thank you. Oh, one other thing. There is no victim contact, direct or indirect, and no return. The alleged victim is JAP. Do you know what that means, sir? It means no contact in person, calling, texting, writing, not even passing messages. That's whether you're in jail or not. And you are not to return to the residence located at 825 North 19th Avenue, Hollywood. Thank you. Valdenor Cardosa.
He's here at Main Judge.
Good morning, Mr. Cardoza. You have robbery, no firearm or weapon.
Good morning, Ms. Anna.
This is for an attempt. Court does find probable cause. Court is going to order no victim contact, direct or indirect, with the alleged victim with the initials TAS. That means no contact in person, calling, texting, writing, nothing on social media whatsoever. What say you, State?
Your Honor, I'm going to be requesting a $50,000 bond. I'm very concerned for the safety of the community. The reason being, and it's mentioned in the arrest warrant affidavit, Your Honor, Mr. Cardozo appeared before Your Honor last Friday for a possession of cocaine and an attempted robbery with a deadly weapon. I've provided the court with a copy of the affidavit. Now, I will note this did occur before that alleged incident, but as you can see in that alleged incident, he attempted to rob a woman at knife point at the same exact bank. And it appears would appear to be his MO. This is now the second case before you where he's attempted to rob people at this same bank, and I am very concerned for the safety of the community. Also noting, At some point, he, according to the report, he extended his two fingers and his thumb to appear as if he was holding a gun in front of the victim. And I submit, Your Honor, while you set a $10,000 bond in pretrial with the GPS last week.
No, actually,
Oh, that was on the, I'm sorry, I apologize. That was on the arrest warrant, I believe.
mhm,
I believe if Your Honor was
by
aware.
Judge Lynch.
I believe if Your Honor was aware of these allegations, that it would not have been the same bond.
Mhm. Gave a post-Miranda statement reference to the 3 robberies he was a suspect in, which occurred at the Bank of America. He identified himself in surveillance videos. Okay. Defense?
Judge, I believe law enforcement picked him up from his home, and when they were speaking to Mr. Cardosa, they informed him this probably should have been charged at the same time as the other offense, and this would have been before you 4 days ago. Judge, he was released on a $10,000 bond. The person who posted his bond was his wife. She basically sells stuff over the internet. From speaking to Mr. Cardosa, most of all their funds were exhausted in posting the initial bond. What we're going to be asking you to consider is setting a $2,000 bond on this attempted robbery. He's 37 years old, been here since 2011. Right now he's unemployed, he's looking for work, but he was working in construction. They have 2 children, and right now his wife's not in a position to post the sort of bond the state is suggesting. So that's why I would ask you for a $2,000 bond on Mr. Cardosa's behalf, Judge.
What does he do for a living?
Right now, he's looking for work. He's not working. He was working construction, and whenever he worked, he told me he got anywhere from $60 to $80 a day. But right now, no, he's not working, Judge.
Okay, anything further?
No, Judge.
Okay, the court does know that this was an attempt. However, he did pull up and park next to the victim's car. This is the 3rd time he's allegedly attempted or robbed someone from an ATM. So court's going to set his bond at $25,000. No direct contact, direct or indirect, with TAS, GPS level 2. Sir, you're not to return to 900 West Sample Road, Pompano Beach, Florida. Anything else, Dave?
No, Judge.
Also, sir, no firearms, no possession of any firearms, ammunition, or weapons. Thank you. Derek Van Weeden. Good morning, sir. You have drug paraphernalia, possess and/or use. No bond attached to that. That's basically an ROR. No bond required. Same thing, obstructing without violence, resisting an officer, count 2. Count 3 is tamper with or fabricate physical evidence, $1,000 bond. Court does find probable cause. Court is going to order no return, sir, to Spirit Halloween at 4020 West Hillsborough Boulevard, Deerfield Beach, Florida. If you go back there, sir, you'll be arrested. Do you understand?
I understand, that won't be a problem.
Okay, is your mailing address, sir, 4190 Turnberry Circle, 1302, Lake Worth?
No, it's currently 726 Sunny Pine Way.
Is that one word or 2?
2 words.
Sunny Pine, 726.
Sunny Pine is 2 words.
Okay, Sunny Pine Way.
Apartment D2, Green Acres, Florida, 33449.
Okay. Anybody wish to be heard?
Yes, Judge. We're going to be asking the court to consider releasing Mr. Van Weeden, ROR, or on a pretrial release. He's 28 years old, been living here his whole entire life in Florida. He currently goes to school. He goes to Palm Beach State College. He's studying business administration. He is a sophomore. He is on Florida prepaid.
State, what's your comments and his priors?
I don't have an objection to pretrial. His criminal history, 09 out of Boynton, possession of oxycodone, loitering or prowling, 09, fleeing and eluding law enforcement.
Okay, go ahead, Mr. Romero.
Judge, right now, as you heard, his contact with the criminal justice system is remote. About 9 years ago, he lives with his parents. His dad works at Walmart. His mom is a hairdresser. So financially, they're very on a tight budget. So that is why we're asking for Your Honor to consider either ROR or in the alternative pretrial release.
This was just a normal situation, but I'll tell you what, I'm gonna put him on standard pretrial supervision based on the allegations. He's gonna have to report within 24 hours of his release. To pretrial, report once a month, call in twice a week. Sir, just remember, no return to Spirit Halloween, otherwise you'll be arrested. And I updated your address. You can go to www.browardclerk.org and check your address. Check your address, check your court date. And if not, you could call your attorney, the public defender's office, okay?
Thank you so much, Your Honor.
Thank you. Michael Weston, please. Michael Weston, step up, please.
He's approaching, Judge. Mr. Weston, come on up, sir.
Okay, let him bring him up anyway. Okay, Mr. Weston, good morning, sir. You have grand theft between $300 and $5,000. Bond is set at $1,000. You bonded. Court is gonna order no return to the Guitar Center at 4449 Lyons Road, Coconut Creek. You go back there, you'll be arrested. Your mailing address, 1060 Southwest 6th Ave, Deerfield Beach?
Yes, ma'am.
All right, good luck to you. Look for your court date. Thank you. Jonathan Cannings, please.
Mr. Canning is here present, Judge. He declined the services of public defender.
Okay, Mr. Cannings, you have some serious charges. You have violations of probation. If you can't afford an attorney, I can appoint the public defender. Do you have a private attorney, sir?
Yes, ma'am.
Who's your private attorney?
Patrick Curry.
Patrick Curry. Can someone call up Mr. Curry?
I haven't spoke to him. I was going to take care of it next week when I go back to court.
Okay, so do you want the public defender just to represent you for today, or would you like us to call Mr. Curry, or would you like to represent yourself?
Represent myself right now.
Okay. All right, Mr. Cannings, you have resisting an officer without violence. There's no bond attached to that. Count 2 is destroy, damage, alter electronic monitoring equipment, $1,000 bond. Counts 3 through 5 is violation of community control, no bond hold. Counts 6, 7, and 8 is violation of probation or community control. You have a no bond hold. You are going before your division judge, who is Judge, let's see,
Siegel.
Judge Andy Siegel, on August 27th at 8:30 a.m. Court will set bond on count 2 at $999. Thank you, sir. Good luck to you. Next one is Travis Davis. Mr. Davis, come on up.
He's here at Main, Judge.
Okay, Mr. Davis, you have grand theft between $300 and $5,000, bond set at $1,000. Count 2 is obtain property under $20,000 by fraud, bond set at $5,000, $6,000 total. Court does find probable cause, no victim contact, direct or indirect, with the alleged victim with the initials MPR. Do you understand what that means, sir, or do you need me to tell you what it means? I don't mind.
I understand what you mean.
All right, what say you, defense?
Judge, we're going to be asking for the court to consider releasing him on pretrial release. I'll see if the state has an objection before I go on.
I would.
Okay, is this mailing, let me just check its address, 10248 Northwest 33rd Street, Coral Springs?
Is that your address, sir? Where
Yes,
you get mail?
that's my address.
Okay, thank you very much. Go ahead.
Judge, my understanding is, he's 33 years old, been living here since 2012. He's self-employed, he's an electrician. He makes on an average about $200 a week doing that. He lives locally here in Coral Springs. He rents an apartment by himself. He's been there for about 3 years. I apologize, not by himself. He has roommates. His total share, the total rent is $1,700, and he divides that with his roommates. Judge, he's going to be contacting a friend of his to post his bond. She does hair for a living, so that's why he advised me he really doesn't think that she can afford the bond, and that's why we're going to be asking the court to consider releasing him on pretrial release on these nonviolent offenses, Judge.
State.
Your Honor, I see only one prior, 2012 domestic violence assault, and for that reason, I don't have an objection to the court reducing the bond. However, based on the amount that was allegedly stolen in this case, over $10,000, I do believe some monetary bond is appropriate. And I apologize if the court didn't already order it, just also requesting no victim.
I did no victim
And
contact.
nothing further.
No problem. All right, court's gonna do standard pretrial supervision, report within 24 hours of your release. I want you to report once a month, in person, call in 3 times a week. 3 times a week, Ms. Patrice. Call in 3 times, you have to report within 24 hours of your release there. Mr. Romero's giving you a map, thank you. Next one is Gavin Inico.
Mr. Inico has bonded, Judge.
Gary Boynton.
He's here with us at Maine.
Okay, Mr. Boynton, you have deliver heroin within 1,000 feet of a place of worship or a convenience business, $7,500 bond. Count 2 is possession of fentanyl, $1,000 bond. I think this was the one with the feet.
It stated it would happen, the transaction happened directly in front of a convenience business.
Okay. Okay, the court does find probable cause. What say you, defense? $8,500 total.
Yes, Mr. Boynton's not going to be able to afford that at all, Judge. Unfortunately, right now he is employed. He works for a company called Cut Above. It's a landscaping company. He's been there for about 5 months, making about $80 a day. He lives in Tamarack where he rents a room, and his monthly rent is $700. So as you can see, basically all of his pay goes towards paying his rent, food, and whatever excess money he has a 4-year-old son that whatever leftover money he has, he helps his son out with his expenses. Judge, my understanding is he does have contact with the system, but I believe it's been a couple years. And he has no one to contact to help post his monetary bond. Whatever phone numbers of friends he has, my understanding is that the phone was taken into evidence, so he doesn't have access to any phone numbers, so that's why we're going to be asking the court to consider releasing him on pretrial release.
6606 Northwest 78th Street, Tamarack.
Yes, ma'am. Yes, Your Honor.
All right, state.
Your Honor, I'd object to pretrial on a first-degree felony. His criminal history is 2010 theft, 2009 possession of oxycodone, he violated probation, 2008 possession of cannabis and loitering and prowling. And because of that record, I have no objection to the court reducing the bond. I do believe some bond is appropriate, though, on a first-degree felony that is punishable by up to 30 years in state prison.
Right, here's the thing, it says the CI walked to the predetermined meet location. So this is what the court's gonna do. I'm gonna put him on a GPS open schedule. What kind of bond can he afford? Hearing no response, $1,000 on one, $1,000 on one, ROR on 2. Okay, thank you, I think that's more than reasonable.
Thank you, Your Honor.
Welcome. Brandon Alton Reed.
Come on, sir.
I want you to call.
Yeah, I'll call.
Right down the
Mr. Alton Reed, you have driving while license is suspended, third or subsequent offense, $750 bond. Count 2 is an unlawful speed. I don't need them, thank you though, I appreciate it. Count 3 and 4 is a probation violation, sir. You're gonna be held no bond. You are going before your division judge, FF, who is Judge Ernest Calra, on August 29th at 8:30 a.m. Court does find probable cause. What say you, defense, with regard to the $750 bond?
Considering as a no bond hold, Judge, nothing to add at this time.
749 on count 1. Thank you, sir. August 29th, Judge Calra, thank you. Dwight Jones? Here, Miss Patrice, I signed these two for you. Oh, one more. Okay, hold on. There you go. All right, Mr. Jones, good morning, sir. You have grand theft between $300 and $5,000 bond. Count 2 is a warrant for violation of pretrial felony. You're held no bond. Actually, that's not for magistrate. Court does find probable cause. Court is going to order no return, sir, to the Home Depot located at 750 University Drive in Coral Springs. If you go back there, you'll be arrested. What say you, defense?
Judge, I understand he has a no bond hold and it's not for magistrate, nothing we, so considering that, we're gonna defer any bond modification in front of the judge.
Okay, no problem. We'll leave the well, we're not gonna leave the bond. We're gonna set it at $9.99. Thank you. Good luck to you, sir. Don't return to that Home Depot if you get out, okay?
Yes, ma'am.
All right,
Good luck,
have a
sir.
good day. David Gomez, please.
Mr. Gomez, come on up, please.
Okay, good morning, Mr. Gomez. All right, Mr. Gomez, how you feeling today?
Not good.
All right, well, we'll try to do this as quickly as possible. You have DUI, alcohol, or drugs, fourth or subsequent offense. We need to talk about bond. Counts 2 is refused to submit to a DUI test. There's no bond attached to that. 3, 4, and 5 are civil traffic infractions, driving on the wrong side of a roadway, driving without lights, and improper left turn, Court does find probable cause. What say you, state?
Your Honor, I'm gonna be requesting a $20,000 bond, considering this is his fourth DUI. His previous
Thank you.
DUIs were 2014, 1996, 1991. He also, from what I can tell, has 2 prior DWLSs, 2016 and 2011. In addition to the bond, I'd be requesting pretrial release with a TAD monitor, no alcohol or intoxicants, random testing, and no driving until further order of the court.
Defense?
Judge, in speaking to Mr. Gomez, there's no way he's gonna be able to afford to come anywhere close to that. I do understand allegedly this is his fourth DUI. In 2014 is the last time he was arrested on a DUI. That's 4 years going before that, in 1996, which is, I believe, 18 years prior to that. Judge, he's 54 years old. He's been here for over 30 years in South Florida. He was working for an electrical company. Unfortunately, he had to get surgery, and because of his surgery, he was out of work for 2 months. After surgery, Judge, he was placed on medication, and he's taking medication. Right now, he's had side effects as a result of his surgery that he's actually dealing with, and I believe that was one of the bases this case was reset. Unfortunately, he did encounter some sort of financial hardship. He lost his house in December, and he was basically forced to move in with his girlfriend and his girlfriend's daughter. Right now, they're allowing him to stay there basically rent-free. When he was arrested, my understanding, Judge, is he was not allowed to bring his phone, or his phone was left in the vehicle. So he has no way of contacting anybody to let them know to post his monetary bond. His girlfriend, who's helping him out, is retired She doesn't work, so financially, she doesn't really have the funds to post his monetary bond anyway. Judge, we're gonna be asking, we have no objection as far as what the state suggests as far as placing him on supervision, pretrial, with the TAD monitor, ordering no alcohol, ordering him not to drive. But Judge, financially, he can't afford to post a bond, so we ask you to impose pretrial with the TAD monitor on Mr. Gomez's behalf.
And Your Honor, I just want to note, the driving pattern in this case is also aggravating, considering the allegation is he was driving northbound in the southbound lanes of South Flamingo Road in Davie. This was, he didn't have his headlights on. This was approximately 20 minutes after sunset, and this was at, as I just stated, a little bit after 8 o'clock on a Saturday night, so thankfully no one was injured.
Judge, could I have 2 seconds? If Mr. Reedy can contact me on the phone, I just need to ask one question.
Sure, no problem. Take your
Thank you.
time. All right, go ahead.
Judge, I just wanted to get some additional piece of information, having
That's
learned some
fine.
information. The defense has nothing else to share.
All right, this is what the court's gonna do. No alcohol or intoxicants, random testing at the defendant's expense, prescription medications allowed as prescribed, TAD monitor, no driving until further order of the court. Court is gonna do a GPS level 2. On count 1, the court is going to set a $2,500 bond. And count 2, it's an NC, so it's no bond required. Thank you, sir. Good luck to you. Paul Lennox, Oster Paul, please.
Mr. Paul, come on up, please.
Okay, Mr. Paul, you are charged with 1 count. It's actually a change of charge to attempted murder in the first degree. Court does find probable cause. What say you, State?
Your Honor, the state would be seeking a no bond hold upon the finding of proof evident or presumption great for first appearance purposes only.
Defense?
So I remember this case. This is the one where the victim asked Mr. Paul to place his daughters into a prostitution ring and ended up getting injured as a result. I would ask the court not to be holding Mr. Paul without bond on this particular case. I think I made all these same arguments on his behalf the last time he was here. It appears the victim is involved in prostitution, so certainly does not come to the table with clean hands. The court does not have to hold Mr. Paul without bond on this case. You can exercise your discretion even if you find that the proof is evident, the presumption is great. I'd argue, though, that it is not. Based on the affidavit and the police report, the incident report, I should say, that I've reviewed, I would submit to the court that the highest standard we have in criminal justice, which is proof evident presumption great, has not been met. And even if the court disagrees over my objection, I think this is a case where bond is appropriate.
And Your Honor, I would just note, it's amazing when it's the victim's version of events, it's alleged. When it's the defendant's version, it's provided as a matter of fact. Though that is what Mr. Paul stated to law enforcement, what was going on. And there's nothing before the court to confirm that. What is confirmed and is corroborated is that, by his own admission, that Mr. Paul stabbed the victim multiple times, causing serious injuries, a collapsed lung, that law enforcement stated he would have died if he didn't get proper medical treatment. Additional information that is before the court now, that was not before the court previously, is that Mr. Paul, after acting in from what he claims to be self-defense, took the knife back with him to his home, which I would argue, tend to corroborate that he brought the knife there, as opposed to his claim that he took it from there. And it would appear from the evidence that he decided to clean the blood off the knife because he had a rag filled with what appears to be blood on it found in his possession, which I would also argue shows a consciousness of guilt. Because why, if someone acted in self-defense, justifiably, why would they feel the need to clean off the weapon that was used in the matter?
All right, I have reviewed the probable cause affidavit and other documents in the supplemental report filed in your case, and I find probable cause. I further find the proof of guilt to be evident or the presumption great. Therefore, Mr. Paul, you're going to be held no bond on attempted murder first-degree charge. Until further order of the court, this order is without prejudice, sir, for you to file a motion to set bond with your assigned division judge and request a hearing under State v. Arthur. The court is also going to order no victim contact, direct or indirect, with the alleged victim with the initials JM and JM's family.
And Your Honor, I can advise counsel and Mr. Paul, he is scheduled for arraignment next Monday morning before Judge Shearer at 8:45 in the morning.
Okay, did you hear that?
Yes, sir.
Okay, no victim contact, sir, direct or indirect, with JM and JM's family. Thank you. Okay, we'll be back at 1 o'clock. Thank you.